to mention item number, supply list item number 50 and 51. In this case, Mr. Surajit Dutta-
Item 50 and
item
51.
51. In this case, the senior advocate, Mr. Surajit Dutta will argue the matter.
Who?
Surajit Dutta, Mr. Surajit
Okay.
Dutta will argue he is out of station. Let the matter may kindly be fixed on 17th, my lord. I have taken the consent of the other.
17th.
17th.
Okay. On the prayer of the honored council for the parties, list this matter on 17th.
Wait, please, Lordship. Lordship, beg to mention item number 16, Lordship. Item 16, Lordship. Lordship seeking an accommodation for a week, Lordship here.
What remains in this matter?
Lordship, Lordship may kindly hear my senior on this.
No,
one.
no.
Because Lordship,
What remains, tell us.
then Lordship,
We'll examine the issue in appropriate cases.
the Lordship.
You have been protected. Your statement is recorded matter as there. Whether you have been granted the relief.
Lordship.
Then?
Course of action not be taken. That relief have been granted.
Huh?
That no course of action.
That's all. We'll close it in terms of that order.
Lordship, then
That's all. No, nothing. Yes.
Lordship, I beg to mention item number 22.
Yes.
My lord, engaged counsel is not present here, that's why. He is out of station for his mother since he has to
On
go
the
his.
prayer of the learned counsel for the petitioner, may trust and adjourn and be listed after 6 weeks. Yes.
Please, my lord. My lord, item number 52, my lord. It was fixed today for disposal, my lord. Mr. Goyal, he has some difficulties today, my lord. It will be taken up day after tomorrow, my lord.
Which?
52, my lord. 5 supplementary.
It was some more time. Yesterday, we got that information from the Kharagpur ballot. It will take some time. So some time, more time. will be given.
On the prayer of the learned counsel for the parties, matter stands adjourned and be listed after puja vacation.
Master.
Lordship, item 6, my lord. I am praying adjournment is for a week, my lord.
Why?
But they have misplaced my file.
Okay, we'll allow your repetition. Yes.
May it please your Lordship. Lordship, I
Come.
beg to mention item number 10 and 24.
10 and
24, Lordship. Lordship, senior counsel is out of station, so matter may be taken after puja vacation. Lordship, I have already taken the consent of other party.
item number 10 and
Lordship, DCK Hazarika.
wait for your turn. Yes.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 11, lordship. Engaged counsel out of station for his personal problem, lordship. I have taken consent from other side.
Wait for some time. Yes.
I'm praying for an accommodation in item number 26, your Lordship. To
Affidavit filed. They file affidavit,
your Lordship.
not filed.
And
Wait for
actually,
the.
we were to also file, we were to give extra copies, but there inadvertently we did not give your Lordship.
Wait for your turn.
Much obliged.
For order no step item 1.
Lordship, we are appearing for respondent number 7, my lord.
Yes. Anything survives?
Lordship, we will ask to take steps upon responding to
No, steps will come later on. Anything survives in this matter?
I think so.
Now, whether the rural outlet has been established, who is for the respondent? Huh? Private respondent. This has been said already.
Interim order, my lord.
Interim order says nothing that
Yes, my lord. True, my lord.
strictly prohibited.
That may be adhered to, my lord.
That may be adhered. We'll close
my
that. Close this writ petition in terms of that order.
In terms of that order, it may be.
We'll close it. We do not know your senior. You'll have to come with preparation. It's not like that. What is your prayer?
Prayer. Lordship, page number 29 is my prayer, not to direct respondent.
You want to take steps upon whom?
Lordship, upon respondent number 6.
Who is respondent number 6?
Division manager. Narayan. Regard to respondent number 5, it is
You are respondent number 5. 7.
Private.
What about 5?
it is complete, Your Lord. Narayan.
Only respondent number 6. Learned counsel for the petitioner pressed for and is granted. Divisional commissioner of which petrol pump? Which company?
Narayan Energy. Respondent number 5.
Respondent number 7.
7 is private respondent, my lord.
You are 7.
I am set.
Hmm. So your petrol pump is not established.
No.
There is no stay.
Well, in view of the interim order, my lord,
What is the interim order? You have been given to
No,
strict
no,
follow.
I'm saying, my lord, that may be adhered to, my lord. What is there, my
No,
lord,
that you, this up to the company to adhere.
up to the company?
But they have challenged your settlement, so something remains in this writ petition. The learned counsel for the petitioner is permitted to take steps for issuance of notice upon respondent number 6 during the course of the day. Full stop. If no such is taken during the course of the day, this matter will be treated as dismissed without further reference to this court.
I see.
No word. None appears for the petitioner on call. None appears for the parties on call. None appears for the petitioner when the matter was called on 22/3/2023. Full stop. Office note dated 5/9/2024 reflects that pursuant to this court's order dated 23/12/2022, no steps for service of notice upon respondent number 1 and 2 has been taken. In view of the aforesaid, the writ petition stands dismissed for non-prosecution. Yes.
For orders item 32 and 33.
In the case number 2889 of 2011,
Mm.
according to the office note, last office note dated last office note, Lordship, the amended cost title has not been submitted by us. Lordship, I apologize profusely for that. We'll be submitting the amended cost title in the course of the day.
Learned counsel for the petitioner submits that the amended cost title be furnished in the section in terms of this court's earlier order dated 5/6/2024 shall be furnished before the section during the course of the day. Full stop. This matter is pending since 2011. Full stop. It's no such cost title is submitted. Full stop. This matter may be treated as dismissed. Not submit during the course of the day. This matter may be treated as dismissed for non-prosecution without further reference to the court.
Obliged.
The government has filed affidavit. I also filed reply, my lord. Letter is relating to my lord paying for compensation, my lord.
Huh?
Issue,
What is the issue?
my lord, relating to my lord with illegal arrest by the Gokpur police, my lord. So already they have taken bail, my lord, and thereafter, my lord, without, in spite of the knowing that they are taking bail, my lord, even I put permit to page 34, my lord.
As the pleading, huh?
I'm appearing on behalf of the
Police
respondent number 7,
Ah.
police officer, SDPO. Well, I'll allow me some time, for filing my affidavit, because I received this through DIG, it has,
When?
it has
When have you received?
about
2
2 weeks back,
weeks back. Mr. P. Bora, learned counsel representing respondent number 7, pressed for and is granted 10 days time to file affidavit in opposition. Full stop. List this matter on 30.
May it please the Lord. My lord, the writ petition is connected to the criminal petition. The criminal petition under 482 was filed challenging a complaint case where there was a stay order provided. After the stay order was provided, it was furnished to the trial court, where the trial court says, no, we will keep on going and issued non-bailable warrant of arrest. Against that, a writ petition was filed. My lord, in Laujoma Court's order dated 10/6/24, there has been stated that present address of respondent number 2 has not been given. My lord, we have taken registered post, postal Talabana, and we have taken Dasti service also. The address which was given in the complaint petition, the person is not residing over there. So, my lord, the only recourse at present left for me is the paper publication. That's much.
Okay. Now, it is Mr. P.K. Roy Chaudhary, learned counsel submits that the steps upon respondent number,
In my lord, the writ petition respondent number 2.
respondent number 2 was taken by way, through registered post with AD as well as through usual process, usual process. However, such service could not be completed as the respondent number was not found in the said place. Full stop. It is submitted by Mr. Rachaudhuri that the address given by the petitioner was the address which was declared by the respondent number 2 himself or herself, himself in connected criminal petition, in a complaint petition.
Case number 75C 2016.
75C 2016. Therefore, the petitioner had no other option but to pray for and publication of notice, publication and issuance of notice through substituted mode and by paper publication. Allowed where this person stays. What is the residence?
In Kamrup.
Kamrup. With having circulation in Kamrup. What is the language of this person?
Is a local Assamese.
Local Assamese. Okay. In an Assamese daily newspaper.
The interim order in both the cases.
List this matter. After give a date after 6 weeks.
After Puja vacation.
We are give because you have to give a date when paper publication. Give a date after 8 weeks. 8 weeks. Give November. 11th of November. Steps be taken within a period of steps through paper publication be taken within a period of 2 weeks from today. Interim order passerelle shall continue till the next date of listing.
Even the criminal petition also, madam.
Court.
37.
Come on. It would pass an order in criminal petition that in view of the order passed in connected WPC so and so list this matter on the same date. Interim order passerelle shall continue. Yes, Board Pujari, item number
Number 37, my lord.
Yes.
Contempt petition, I am representing R1.
Hmm.
Lord, she may kindly, the respondents, my lord, with all respect, they are traveling beyond, my lord, and trying to help out the petitioner. In the.
No, where is the order? Let us see.
Yes. or-
Regarding allotment of
Now,
land
my lord,
and in view
the
of
case of the writ petitioners was that, my lord, that they had deposited a challan, my lord, towards payment of premium for settlement of land, my lord, amounting to rupees 3,86,008 rupees. And my lord, since nothing was forthcoming, they had filed, my lord, the writ petition. Then in a writ petition, my lord, the Deputy Commissioner concerned of Dhamaju district, he files an affidavit and he says, my lord, that no records whatsoever is to be found, my lord, with regard to payment. So it becomes a question of fact. Therefore, my lord, the Honorable Single Judge, my lord, had issued a direction. Although, my lord, in my respectful submission, my lord, stricto sensu, it may not be, my lord, a mandamus per se, but still then, my lord, it says, my lord, that facilitating the above, the writ petitioners, my lord, in view of the above, without commenting on the merit of the case projected by the petitioners, I dispose of the writ petition with a direction to the respondent number 1 to examine the claim of the petitioners and pass appropriate orders therein, as may be permissible
That is
under.
fine. Now, have you disposed it of?
Look, my lord, the difficulty is that, my lord, now, my lord, since the records are not available, the challans are not to be traced, now they have deputed a team. And they have, my lord, already, my lord, set for, my lord, on one occasion in a joint meeting. Thereby, my lord, the respondents are now trying to figure out at least if some part and parcel of land can be identified, so as to, my lord, relocate them. Without going to the fact that, my lord, nothing can be seen, my lord, revived. So they are going out of the way, my lord, and trying to give a benefit.
Okay, that's good.
That is the case, my lord. For that reason, my lord, in the latest communication which.
I've seen that.
Yes, now, my lord, the Director of Land Records Assam, that is the authority, my lord, who is well equipped with all the survey equipments. He has been, my lord, requested to do a survey there. And if it
We
is
are
found-
adjourning it. You file an
therefore, my lord, with
Yes,
all respect,
yes,
my lord.
Mr. Bapujari, learned counsel for the
Respondent 1, my lord.
respondent number 1 submits that the respondent authorities are making all its endeavor to gather materials on the basis of which the representation of the petitioner can be disposed of, inasmuch as it is, according to him, it is on record of the earlier proceeding, it is on record of the writ proceeding also that no records were available, full stop. In view of the above, he prays for an adjournment for 6 weeks. Prayer is allowed. List this matter after 6 weeks.
date may be fixed.
No date. Make a mention.
It will be the happiest person.
Yes.
For 2 years, my lord, they have taken time, my lord.
Yeah, but
Understand,
he
but
has
see,
no-
see,
no
what can we
prima
do?
facie
We
case,
can
my
put
lord.
them.
How can I, my
There are
lord?
numbers of hearing, my lord. I have also appeared hearing on number of occasions.
Do you say that they are not doing anything? Do you say?
They are
If you
trying,
say, we'll ask them that you file a speaking order saying that we don't have any material, so we cannot consider disposal. Let us do that. Let it do that. We'll provide it. That since these are not necessary, they should file a representation. If no document is there, let them say that.
last chance, I'll, see-
What last chance?
I'll see, my lord, whatever. Next.
Everybody should be reasonable.
Yes,
Yes, next case.
I'm so obliged, my lord.
copy to divorce.
May I please, Your Lordship?
Oh,
Lordship, in this matter, direction was given to implead respondent number 5. And accordingly, we have impleaded, and page number 4 is the new amended page with.
okay. In terms of this court order dated. Where is office note?
6/9.
In terms of office note dated 6/8/2020, as per office note dated 6/8/2024, the learned counsel for the petitioner has submitted the amended cause title impleading respondent number 5. Full stop. In view of the aforesaid, let a notice be issued to the respondent number 5. Who is newly impleaded respondent number 5? Who will represent? Respondent number 5. Full stop. Mr. Borua, S. Borua, SR Borua, learned counsel accepts notice on behalf of the newly impleaded respondent number 5. Therefore, no formal notice need be issued. However, extra copies of the writ petition be furnished to Mr. S.R. Borua. Full stop. Notice is made returnable after 4 weeks. Huh?
Lordship, any date may be given.
In the meantime, give a copy. We have seen many
that
cases
is
where notices were issued, dates were fixed, no served copy is been served. After 4 weeks.
Lordship, GA Assam name may be shown in the public.
Registry to reflect name of Mr. S.R. Borua, learned GA Assam in the cost list.
Lordship, any date may be given.
39.
And for respondent number 1 and 2, Lordship.
None appears for the petitioner call.
Yeah, my lord, this case, they have filed against the original application in the learned debt recovery tribunal was allowed, then it went to the recovery officer, the property was addressed. So
Now, should be sold or any interim order, what?
there's no interim order. The original application was filed way back on the year 2011. Bank has filed. And they have appeared and filed written statement.
In the proceeding.
Yes. Then that original application was allowed.
Ah.
Then it went to the recovery.
Now understand, now they have challenged that there was a settlement.
No, there is no question of because.
No, they say that it is beyond control, loan could not be paid.
Yes. My lord, actually the original application was allowed.
Now, what is the present status of the property?
It has been sold by the recovery officer.
Sold and it
Yes.
was taken by some other party.
Yes, it has been sold in the recovery.
None
proceedings.
appears for the petitioner on call, though Mr. De Learned Counsel
Mr. Nandi Lordship.
is present representing
Respondent 1 and 2.
respondent number 1 and 2. The present application is a challenge an order of the recovery of officer arising out of
Arising out of Lordship, original application number 6 of 2011.
arising out of
Original
application number
6 of 2011.
6
Of 2011.
6 of 2011. Full stop. The property mortgage has already been sold and sale certificate has already been issued. Full stop. Already been issued. Full stop. Considering the matter in entirety and also considering that none appears for the petitioner on call, the present writ petition stands dismissed for non-prosecution.
Obliged. Mr. Nandi Lordship, not Mr.
Yes,
G.
record.
Obliged, Lordship.
Please, my lord. In this matter, the petitioner is a contractor, my lord, and the respondent authority published on NIT. And based on that NIT, the petitioner participated in the NIT, and he is the L2 bidder, my lord.
He was L2.
Petitioner is the L2 bidder, and my lord, L1 bidder is respondent number 6, my lord. Here, my lord, in the NIT is that is.
Now, what is the walk?
Walk is the road from Home City PWD at Kolkata to SRD complex, my lord. The construction of road, my lord, yes.
Construction of road.
Here, my lord, NIT is at page 12, and my lord, in the ND column number 1, rate should be quoted as per schedule of
Let
rate.
us understand what is the walk pass. We'll go to the rate later on. What is the tender?
Tender is for
Construction of what?
the road from Home City PWD at Kolkata to SRD complex, providing disaster mitigation measures under SDMF for the year 2023 to 24 in North Lakhimpur district, my lord.
Okay. Now,
Now, my lord, as per NIT, my lord,
who is representing for the private respondent? Okay. Now there is a stay. Mr. Nayak, there is a stay.
Yes. I'm not sure, Lord. Yes, no. আবার check করা আছে? Day 9. First order to that.
Is there any stay?
No, no.
That road is concluded, constructed. What is the present status?
Second status.
Anything to be adjudicated?
So
But
far-
there was an interim, that no final decision be taken for settling the matter. The said provision, however, would be reconsidered once obtaining instruction. Decision 412. Motion of day after tomorrow. Interim order pass earlier, continue till the next date of listing. Interim order pass earlier to continue till the next day. Interim is there.
First order, no interim is there.
Yes, first order interim is there. See, it is however observed that till the next date fixed, no final decision be taken for settling the matter. The said observation, however, would be reconsidered on obtaining instruction. Thereafter, all orders interim must continue.
Lordship, in fact, Lordship, I received instruction on 12/20/23 itself, Lordship.
But
He-
12/20, 13/12/20, it was again taken.
And,
Again, a matter was taken up. Then drafty service was directed and interim order pass earlier shall continue.
Yes, Lordship.
Then thereafter, matter was listed on 8/1/2024, interim was continued. Then on 20/1/2024, interim to continue.
But my instruction is silent so far as that interim is.
Everywhere
Lord-
interim.
Lordship, so far as present status is concerned, Lordship, let me obtain the instruction.
Okay,
But so
okay.
far as his status is concerned, his bid was rejected.
His whole case is that the L1 is below 10%,
L1 has also been rejected.
rejected.
Work was allotted to L3, he was L2. And his bid was rejected because of his past performance in executing other work.
So we can decide this matter, what more is required.
That is the only.
You have that instruction. So your grievance is against L1. L1, what-
And L3 also, I have made L3 is, L3 also.
have you taken steps?
Yes, my lord, respondent number 7.
On the prayer of this matter is ready as regards service. 6 and 7, is not it?
6 and 7.
This matter is ready as regards service. Accordingly, list this matter on. Give a date next week. These are important, public importance. 19th of September 2024. In the
19, I am not available.
give a date.
My lord, 10, 22, 23, I mean.
23.
Yes.
23rd of September 2024. In the meantime, Mr. Nayak, Learned Standing Council for PW may complete his instruction. The interim order pass earlier shall continue till the next date of it.
All right.
23.
41.
Just have this, what is the
Lots of
exact
bylaws.
position? And if stay, and what happened and what is the bid and who has been elected, you just have that instruction.
Lordship,
I do not think you will require a details affidavit. We can see from the record and instruction and decide.
Lordship.
Yes, item number.
May it please, your lordship. My lord, here in the contempt application, I have received 2 affidavit from both the respondents, my lord. My lord, from the very beginning, when I filed the writ petition, there was a stand taken by them that the entry to my road, my entry to my factory is closed.
Hmm.
And they have stated in that, my lord, the instruction, the order
But
itself.
the urgency you have expressed, that,
Because of the.
no, not because of that. We are not convinced of that. We'll need some delivery. You file that rejoinder. On the prayer of Mr. P.K. Roy Chaudhary, matter stands adjourned, enabling him to file rejoinder affidavits to the affidavit in opposition filed by the respondent number
1 and 2.
1 and 2. List after puja vacation.
We are yet to file our affidavit regarding the outcome of the SDLC lawsuit.
What is the issue? What is the
The
issue?
issue is, my lord, the petitioners were awaiting their permanent settlement in the form of a, my lord, following, in pursuance to direction issued by this court for a permanent market.
Okay.
As of now, my lord, they are sitting by the southern side of the ML Sharma Road, my lord, in Fancy Bazaar, the jail wall side. Now, my lord, what has happened?
These are the vegetable vendors
Vegetable vendor, fruit vendor, all that.
from jail to that road.
It will be, my lord, in that, Motilal Sharma Road, my lord, that, on the
Whole
side
jail.
of the jail,
Side of the jail.
on the side, between the jail, there is a strip of land. So in that,
Not only strip of the lane, at 5 AM in the morning, the vegetable market starts from the jail up to Moskwa.
we are not concerned with that part.
But this is the continuous vegetable. I had the personal, should I
No,
take, I had the
no, my lord.
personal experience of cycling there. Day before yesterday.
My lord, no, they were, my lord, they, beyond Kedar Road, we are not concerned.
Beyond Kadarat, you are not.
We are
concerned.
not. Only that wall, my lord. And then again, my lord, that parking also starts, so there is also not, my lord, from the point, my
Anyway,
lord,
now what is,
Well,
you want a separate settlement
they
somewhere.
have committed to it, respondents have committed to it. And it is there, my lord. At this point of time, my lord, there is interim orders passed in more than three writ petitions actually, including the present one. That we should be content, the status be maintained, my lord, as of now, my lord. Now, what has happened, my lord? This matter was listed on 26/7 last. Your lordship, after hearing the parties, fixed on 11/9, directing them to file one, the district commissioner and the other, the GMC, my lord, to file affidavits. My lord, I have annexed that order. Now, just after that, on 16th of August, in the morning, my lord, the
16th or 14th.
16th of August.
Okay.
Huh? Well, I'm extremely sorry, man. On 3rd of August, 3rd of August, my lord, in the early hours, my lord, the GMC authorities came along with police force and all that, my lord, and they brought down 14 of the shops, saying that they want access. Before that, my lord, they didn't take any leave or anything, my lord. They are setting up some refuse disposal plant or whatever that they can do. But otherwise, we were protected by the interim order. That day, my lord, and you have to say, you also will recall, my lord.
Yes, tell us, when can we decide this matter?
Lordship, as per the last order dated lordship, we are supposed to file our affidavit. Because earlier land was, which was proposed in their favor, revenue department has some, was not.
We do not know.
We are
File an
proposing another.
affidavit and give a
Yes.
proposal, otherwise we'll say that at any circumstances, they should not be disturbed in that area.
We are in regard to lordship, the proposing the allotment of land.
Oh,
Lordship.
You need so much of time.
Lordship.
Who are the other departments? Who are the other departments which involved for settlement of this land? Who is the earlier order?
26/7/2024.
No, not that original order giving you the,
That is 9/8, my lord. In the
where do you get it? Read petition.
9/8, my lord.
2793.
Yes, my lord.
Page?
My lord, in the IA itself, we have annexed it, my lord.
Page 44.
Page?
Page, my lord, 21 of the IA, my lord. Page 21. Huh? My lord, your lordship will kindly see the interlocutory application, the first annexure, my lord. Page 22, it starts, then the direction is there.
IA in IA.
IA, my lord. The
Page
direction
20.
is there, page 27.
Yes.
IA number, my lord, 2682.
2682. IA 2682.
There is another IA for implement of PWD department that I will come later on. Page 27 of that, my lord. Order dated 9/8/21, starts at page 25. Page 27. Bottom, my lord. After notices were issued, may I read out. Till the next returnable date, the response GMC and official shall allow the member of the petitioner society to operate the market from their respective stalls, subject to payment of necessary taxes assessed by GMC officials as per the present rate. It is further clarified that this interim order shall be strictly followed by the members of the petitioner society only and shall not allow any proxy members to operate the market, causing traffic congestion to the road. And on the other hand, it will be personnel from the GMC who are responsible for collection of the taxes. My lord, till date, my lord, from 21, we have paid more than 55 lakhs as my lord municipal tax. In view of the uncertainty being faced by the members of the petitioner society, with responding GMC along with Deputy Commissioner shall take steps to complete the allotment process. Now, on the last date, they said, my lord, the land that they were going to allot us, my lord, falls in that some eco-sensitive zone or something.
Yes, yes.
And that is why that was not practicable. So they were to meet again in August, in the month of August. That subdivision level land, that land advisory.
Yeah, that outcome I need to obtain, lordship. It's
Day after
awaited.
tomorrow,
Lordship.
Monday, Tuesday.
Lordship.
Now, here is another aspect. After violation by them, we filed a contempt petition. That was also listed today before another court, my court number 17. In that, my lord, order is passed to get that contempt matter listed along with this. So
When matter is fixed?
23rd.
Okay, list this matter on 23rd of September 2024. By the aforesaid date, the Deputy Commissioner, full stop.
It will be
The-
district commissioner.
The District Commissioner shall file an affidavit in terms of this court's earlier order dated 26/7/2024, passed in WPC, passed in this case, right in the writ petition, passed in this case on or before 20/09/2024. Inasmuch as this matter involves settlement of the petitioners in an in a area for continuing with their business activities. Full stop. Time and again, the petitioners are filing interlocutory application alleging that even after specific interim orders protecting their present status was passed, the authorities, more particularly the GMC authorities, are disturbing their business every now and then, flouting the orders of this court. Such submission shall be considered on the next date fixed after perusal of the affidavit of the Deputy Commissioner. You have filed an application of GMC.
My
Full
lord, I have filed an application. Your lordship's order was passed on in.
No, for implement.
Implement is 2682.
You want to
That is for implement of Chief Engineer PWD roads and the Executive Engineer PWD roads.
IA number.
IA number 2682.
The present application is filed for implement of so and so, so and so. Which paragraph you have stated? Details of the.
Yes, madam. Details, madam, I have given in the prayer itself or otherwise also, madam. I have given. In the prayer itself, I have given detail specified.
Considers the pleading made in the petition. There are specific allegations against the authorities under the PW department And therefore, in the considered opinion of this court,
Para 10.
in considered opinion of this court, the aforesaid respondents are necessary for proper determination of this present case. Accordingly, they are present IA application is allowed by impleading so and so as respondent number
12, 13, 14.
12, 13 and 14 in WPC. In WPC 2793
2793.
2021. The learned counsel for the petitioner is to furnish a amended cost title before the registry within a period of three days. Full stop. Thereafter, registry do the needful for incorporation of same. At the same time, the learned counsel for the petitioner shall also furnish an amended cost title to the learned counsels for the contesting parties. Full stop. Next, main gazette, in view of order. I go to main, this is the IA for implement number so and so. Now again, come back to the main case. In view of order passed in IA so and so, let a notice be issued to the respondent numbers, newly implemented
12,
respondent numbers.
13, 12, 13 and 14.
12, 13 and 14, full stop. Who is anybody from PWD? Your name, please. H. Borua, learned counsel representing the PWD accepts notice on behalf of the aforesaid respondents. Full stop. As
Not the only for 12 and 13. 14 is private party, man. We have to take steps.
for 12 and 13, isn't
Yes,
it?
for 12 and 13.
For respondent number 12 and 13. Full stop. As 12 and respondent number 12 and 13 are duly represented by the learned counsel, no formal notice need be issued. However, extra copies be furnished to such respondents. Full stop. Notice to newly implemented respondent number 14 be issued through registered post as well as registered both ways, so and so. In addition, the petitioner is permitted to take dusty service, but you file an affidavit, okay? So to be routed to the registry. IA 2793 is the implement.
IA 2682 is the implement.
26.
My lord, the writ petition is 2793.
That we understand.
Yes.
Now,
IA 2682.
2682 disposed of. Isn't it?
Yes.
It is implement.
Yes, ma'am.
Yes.
And then otherwise the other IA remains, my lord, 156.
Other
which you
remains,
will also there. Marshal, on 23rd.
23rd. Mr. Borua, file affidavit before 28th. What is the present status? At least. And how much time will you require? The deputy commissioner shall incorporate in his affidavit how much time it will require for allotment of the land as recorded in this court's earlier order dated repetition.
It was 26/7.
In court's earlier order dated 26/7/2024, and also how much time it will require to complete the process of settlement.
$43.
Your lordship, wherein I filed an IA for implement of respondents 5 to 9, your lordship.
What is the case?
My lord, the case is that the bank account of the petitioner was frozen, your lordship. Actually, her husband had lost a lot of money in a stock market scam, your lordship, more than 1.4 crores. And he had transferred about 4.6 lakhs to his wife's account, who is the petitioner herein. Her account was also frozen, your lordship. So the husband also registered a FIR before the cyber police station in Guwahati, but this is a national scam. So in 3 different states, FIRs were registered. And in connection with those 3 states, our bank accounts have been frozen, your lordship. So Gujarat was already implemented, your lordship, initially. And later we came to know that the state of UP, there's a police station in the state of UP and Karnataka, your lordship, where also FIRs were registered in connection with this bank account has been chosen. State of Gujarat, your lordship, otherwise has not, services complete as per the office note, but they have not appeared, I believe.
Now, what should be done today?
Lordship, I'm praying for implement of 5 to 9 who are
Who are five?
Five is the officer in charge of cyber police station where my husband's FIR is registered.
Hmm.
6 is state of UP, your lordship, Uttar Pradesh. And 7 is the station house officer of the particular police station where FIR is registered.
Nothing
Similarly,
will happen. What will you do in this case?
lordship,
Who has frozen your account?
the State Bank of India.
On whose instruction?
These 3 police stations, your lordship. And they have to, your lordship. Firstly, ours is not related to any crime, your lordship. We were the victims. And there was also no report submitted to the jurisdictional magistrate, your lordship, as per section 102 of CRPC.
You'll have to file a, again, if they, you know the action is of UP police. File a high writ petition in Allahabad High Court.
3 different states, your lordship. That is the problem. And jurisdictional magistrate is in Guwahati. That is
But
what
you
is-
say that your account is freeze because of UP police request.
UP, Karnataka, and Gujarat, your lordship.
Heard. The learned counsel for the petitioner. The connected writ petition is filed assailing the action of the authorities in freezing the bank account of the petitioner. Full stop. According, it is seen from the record that such bank account has been seized, freezed by the bank authority on the request of investigating authorities in connection with an cyber crime.
Stock market.
Huh?
We invested money, we lost all the money.
As to a criminal case involving investment of money in stock market, and affairs were registered in different states of India. Full stop. According to the petitioner, she is a victim of such fraud and her account has been freezed on the request of the on the request of the police department under the state of Uttar Pradesh. Accordingly, the present application is filed to implead them as party respondents as respondent number
Lordship, 5, 6, 7, 8, and 9.
6, 7, 8, and 9. Details of which are given at paragraph page 3 of the IA. Considering the nature of allegation and issue involved in the present application, in the considered opinion of this court, in the considered report that if any order is passed, the investigation that has been conducted by UP police may be hampered, and therefore it is necessary to hear the aforesaid investigating authority. Accordingly, the state of Uttar Pradesh, station house officer, and station house officer, Indrapuram police station, not Indrapuram, it's Indirapuram.
I
in-
thought Indira, but then I read it's
Indrapuram police station, Ghaziabad, Uttar Pradesh, side 6 and 7 side be impleaded as respondent number 6 and 7 in the connected writ petition. Full stop. Rest will be no 6, 7. You want to Karnataka also here?
Yes, your lordship.
Okay, on the behest of then we have written in the at the behest of investigating authority under state of Uttar Pradesh and state of Karnataka. Okay, just add you along with UP, state of Karnataka, and respondent number so and so.
5 also, because 5 is where our FIR is registered, Cyber Police Station of Guwahati. They can clarify that we are victims, your lordship.
You have not even made the cyber police station and
Lordship, when we file the police case, That time we were registering the FIR.
That is, before allowed, we give one paragraph. It is also contended by the respondent that where I have said that they are victim. It is also contended by the learned counsel for the petitioner that they had also lost an FIR before the Cyber Police Station Guwahati, and such police station can verify the contention of the petitioners and throw light on the investigation so far made. Accordingly, the said cyber officer in charge or what?
Cyber Police Station Guwahati. Panbajar Guwahati.
mm, hard-earned money gone in the hope of multiple return. That's all. We can comment on that only. Nothing more. This is greed. Nothing more. And nothing will happen until and unless the Honorable Apex Court takes the entire matter to the state. We cannot pass anything except your hope. Accordingly, the officer in charge Cyber Police Station, Panbajar, Guwahati, Assam, serial number 5. I stands disposed of, and rest of the before disposed of, like the earlier order, before the registry, connected cost title, then copy to all the learned councils representing the respondents. Give the amended cost title. Then notice returnable for its both ways. So far related to newly implemented respondent number 5, MSU DAS accepts notice.
What is the number of, Guwahati's number, I am here.
Respondent number 5. Respondent number newly implemented, respondent number 5, UDAS. So no formal notice, extra copies, and rest both ways. Within 5 days. Within 5 days from correction of cost title.
445.
Disposed of.
May I please, Your Lordship?
Yes.
My lord, I am for vacating the expert interim order, my lord.
Where is the order?
And page 25, my lord.
Why should we vacate this order?
My lord, kindly come to annex of
This will require hearing. We'll hear the entire matter. Give a date. Vacating the stay order, we'll have to go into the merit of this case.
My lord, by no confidence motion, the
You give a date for hearing.
Date of admission hearing.
Give a short date if you want immediately.
Pleadings are there, affidavit file.
Fine.
In the main case, affidavit file.
Yes, yes.
Then we'll
Basically, my lord, it's
between
between them.
two-
Yes, I have not filed, I'll argue on law point, my lord.
In the
main case, they have not filed, my lord, just filed the vacating.
we'll accept the treat the we are not disposing of it.
Yes.
We'll treat the vacating as
Yes,
your
yes.
affidavit.
That's correct.
Will that do? Oh, will that do?
my
Are you
lord,
getting
one
my
date
point?
will-
Huh?
One short date may be given.
Give a short date, that is not an issue. Instead of all NRE spending on this and keeping the writ petition separate, will not, nothing will remain. So we are taking up, give a convenient date. If you want to file an affidavit, you file it, or if you say that my pleadings in IA be treated as my affidavit, then it's fine. Okay? Write it down. The present application under Article 226 of the Constitution of India is filed for vacating the order dated 19/02/2024, passed in WPC 819/2024, full stop. Perusal of the material. This court is of the view that instead of taking the matter, taking the IA, entire matter can be disposed of on the basis of the pleadings available on record, including the pleadings made in the IA. Full stop. The learned counsel for the parties also agrees to such proposition. However, the learned counsel for respondent number, you are for respondent number?
Respondent 6, I think.
Respondent number?
No, 6, ne? 6.
Respondent number 6 expresses an urgency considering in its entirety, lists this matter in the admission column on debated before vacation. Hold this from 5th. Nobody will be interested doing on that. At least they will not be interested. All will be busy with motions, huh?
38 September.
But can it be fast or holiday? It is a miscellaneous day or hearing day?
Miscellaneous day.
Normal hearing day.
No, give it on a miscellaneous date.
1st of October, but then can it be taken up on 4th of September? Sorry,
4th
4th
of
of
September, we cannot
4th
go back.
October, no, push up.
Will not go back.
Then on last part of my lord September, your lordship may take up
30th.
on 26th September. It's a my lord hearing day.
26 is a no, not hearing day. These matters we can dispose of in miscellaneous. Huh?
27.
27.
27, I'm leaving. Yes.
Okay.
25th.
25th. Obliged.
Come prepared on that day.
Yeah.
Mr. Talukdar assist us without taking any part. Yes. Yes.
Six.
What is the main method?
Lordship, it is the main matter is the Lordship, there is a tender for the inpatient diet, Lordship of the Nagaon Medical College. Lordship, may please come to the writ petition paragraph 9. I'll just read 3 paragraphs, Lordship, at page 10.
Yes.
Actually, Mr. D.P. Bora, Standing Counsel of Health Department, is on lakes in court number 17.
After some,
Lordship,
after some time, he's on legs.
Seven.
Affidavit we have sent for vetting and your lordship directed us on.
You need
24
Duronto
My lord,
to send for vetting and to come back,
lordship.
isn't it?
Yes, we are.
What kind of Duronto you want? Cable, internet?
Send it, lordship today. So we'll get it, but lordship has directed us on 24/7/2024 regarding when the land acquisition notice was issued as well as my lord, when the handover and taken over was my lord happened. It was my lord notice was issued on 10th of February 2023 and handing over and taking over my lord 27/2/2008 my lord. So that
Award was
instruction-
passed in?
The award was passed.
When notice issued when?
My lord, may I pass it to your lordship?
This is item number?
47.
Where is water resource? Most disturbing department. You want land, land will be acquired, and deputy commissioner will come and say, we have done our part, but no money is deposited.
Money has been handed over, my lord.
No, not in
No
case, in
money.
many of the cases I have seen.
86 lakhs and my lord,
Huh?
plus has been paid, already paid, my lord.
And therefore deputy commissioners are not acceding to your request. In necessary cases, when you say acquire it, they are not acquiring it. You are, on last occasion, you have said it this matter or some other matter. You are saying that even after our request, Deputy Commissioner has not proceeded. Why should he proceed? Because in most of the cases, he proceeds, he hands over you the land. You are not depositing money. Three and odd crores yesterday, one case. And you have deposited some 1 crore. Why should he acquire? Why should he take burden? Yes, what is this case?
There, regarding handing instruction as per order dated 24/7/2024, we have received the instruction regarding date of issue of land acquisition notice as well as handing over taken over. LA case number to prepare.
Okay, so it is under the earlier act.
Earlier act.
Earlier act.
Like, 18
Earlier act. Now they have not been paid.
Till date, madam. And that is why I prayed for
Yes,
that.
what is your instruction? Money deposited.
Value has been total calculated at 86,13,601. Regarding payment
So you are under 2013.
My lord.
Why?
My lord, as per section, my lord, to Act 2013, my lord, if award is not paid, then the proceeding was lapsed, my lord. And if that proceeding was lapsed, my lord, then we have to.
Understand, that's why when award was passed,
Okay.
money paid to you?
No, my lord.
Not yet.
No. My lord. If paid, my lord, then why I come before your lordship?
Award is passed when?
Now I am 70 years old, my God.
Case number is 1 and 2. Date, my lord, I'll have to check, my lord. Can you? Not there. No? Maybe after some time, my lord, I'll check the date whether, but though it is not.
Where have we fixed that Lido case?
The thing is, my lord, the last occasion, my lordship directed to file an affidavit, let the deputy commissioner, district commissioner will file.
Oh, they will not file until and unless
Yes,
we
today's
make them to file. We will have to
We have sent-
fasten the cables.
Today, my lord, next week, my lord, I'll work at the firm to file it.
The present writ petition is filed by the petitioner. Claiming land with a grievance that though their patta land has been acquired, no payment has been made. Full stop. The second, the further challenge, further relief sought is that as no payment of land acquisition compensation has been made during the currency of the Act 1894, until no award has been passed till date, they are entitled for compensation under the Act 2013 in terms of section 24 of the Act. Full stop.
Yes.
MSU thus has obtained an instruction which goes to show that the land was notice of acquisition of the land was served on 10/2/2003 and land possession was taken over on 27/02/2008. Therefore, according to her, in terms of the determination made in Indoor Development Authority by the Honorable Apex Court, the petitioner shall not be entitled for compensation under the new act, even if no award is passed. Full stop. However, to ascertain the claims and counterclaims of the respondents of the parties, an affidavit is required to file, more particularly clarifying the details of the acquisition procession, including showing the dates of issuance of notice under section 4 comma, under section 6 of the Act 1894, as well as the date of award, which was passed in the land acquisition proceeding, whereby the land of the petitioner has been acquired. Full stop. At this stage, MSU, thus learned counsel, submits that the affidavit has been prepared and she is awaiting final vetting of the same from the concerned collector. Accordingly, she prays for a week's time.
My lordship, regarding your lordship's now order, whether those
They-
has been incorporated here, I'll have
No,
to
no,
check,
let
my
it
lord.
see.
3 weeks
In
time
this,
may be
in
granted,
this land acquisition process,
Lordship.
what more you require?
lordship, but
You
they
may
did
say
not-
history, geography, who
my-
was whose son, we are
they-
not
they did
concerned.
Not probably reflected in this.
This
date
is
of
the
award.
vital issue.
My
In
lord-
every
lordship is
cases I have seen,
lordship
a
is-
simple issue is there, nobody is answering.
Lordship
It
is
takes
correct.
5 minutes to decide a matter.
Lordship may be pleased to grant 3 weeks time, my lord. But because I'll have to again check it, my lord.
This
because-
is the issue.
My lord, lordship is correct.
It may be fixed.
My lord.
A prayer is allowed according, 2 weeks time, full stop. Prayer is allowed. List this matter on after vacation. 23rd of October, full stop. No further adjournment shall be granted in
Yes.
this regard.
Clear, lordship.
However, it is made clear that no further adjournment shall be granted
Lordship.
in this matter. Give it to her. Yes, that's it. Item? What is this?
In this
On
case,
the-
Mr. Bhattacharya was supposed to obtain some introduction. Regarding the non-payment of the advocate.
Yes, but proposal. Let us understand the finance for other cases also. What is the procedure in these cases? Suppose a demand is raised, suppose a lawyer's fees or anything. What is this ceiling and what is all this finance department are sending?
Sanction, first of all, my lord, when a
No,
money,
forget about this case. Let us understand for other cases.
yes, if my lord, some quantum of money is required to be disbursed by the state to any person.
Say suppose a department, any department,
Any-
PWD,
any
irrigation, anything.
department, any
Yes.
department. Now, there are circulars issued by the finance department from time to time in several issues. Like, for example, my lord, so far as area salaries are concerned, I'm just putting up an
Yes.
instance. Now, so far as area salaries are concerned, now finance department has issued OM from time to time. Now, as per those OMs, my lord, area salary, so far as the sanctioning part is concerned, the concerned administrative department has been delegated with the power. Earlier, it was with the finance department. Suppose a amount is determined, this is a particular quantum of amount, this is to be disbursed by the state. Say for contractors bill, non-payment of contractors bill,
Anything, yes.
advocates professional bill, whatever it is. Now, area salary, current salary, all those powers, my lord, so far, my lord, disbursing of those amounts, financial sanctions, the authority to provide financial sanction is the administrative department itself.
Okay.
Now, if there is any shortfall in funds, or perhaps if that head of account is not available or some money is to be diverted, then my lord, the financial sanction has to be obtained. Because the finance has to be sourced from
Okay,
other.
so
other-
therefore, this is what for a layman we understand.
Yes.
That this is not already earmarked amount. So therefore, this is an additional or there is no,
Additional-
this is not an earmark.
Earmark.
So I don't have any power. Again, I have to see, this is not earmark. This is the amount. Please give me a
Yes.
fresh sanction.
Sanction. So that is called as FS, financial sanction.
Okay.
Now, once the financial sanction is, my lord, then it is forwarded to the finance department. The finance department will verify the entire issue, examine the claim, and if, my lord, it is found that everything is in order, it can be disbursed, then they accord financial sanction. Matter one goes back to the administrative department concerned. They will have to process and they will have to then earmark the fund. And then, my lord, at the final stage, it is sent for sealing. It is known as FOC, fixation of sealing. And that is the last stage. Now, when it is sent for sealing, it is sent to the budget branch. Now, from the budget branch, it is, my lord, disbursed. It is
Sealing
sent to
means
the
only formal.
sealing. It is the last. Everything is done. It is only a formality.
Now, tell us in this case, PWDs is having, or say finances, irrigation, any department is having a standing council.
Yes.
So there must be some head for payment of salary to this. Then why financial sanction is required?
Now here, my lord, is a case, my lord, where perhaps, my lord, maybe, my lord, my brother advocate concerned petitioner, he had appeared in an arbitration matter, not, my lord, before this honorable court, in regular writ petitions or other that kind of matter.
Okay.
So he has, because in writ petition matters, in writ petitions or appearing before the High Court, the quantum of per day appearance,
We
my lord, per day
understand.
appearance.
There
it
is
is
a
fixed.
earmark per
It
piece.
is fixed.
Fees.
Now here perhaps.
Now
my lord,
suppose I am asking a question. Let
on-
us,
on the-
suppose there is an arbitration. Have you paid the arbitrator's fees?
Necessarily it has to be.
Necessarily it is to be paid.
Yes.
So there must be a head for this arbitration, that for this arbitration, because you will know beforehand that this will be the fees of an arbitrator, this will be the fees of a lawyer. Why then these
Because
litigations are necessary?
lawyers might not raise the bills.
So
later on.
lawyers are placed in a lower pedestal.
Not exactly lower pedestal, it is, my lord, something like that, my lord, after culmination of the proceedings or during the culmination of, because lawyers' fees are not predetermined. Unlike, my lord, we appear in regular matters before this honorable court as standing counsel. In other matters, my lord, they raise bills. Now, in this particular case, my lord, he has raised the bill. It was definitely, my lord, forwarded to the administrative department concerned PWD. PWD has
You
moved the.
cannot raise a bill beyond your, I'm not saying about this case, beyond if your limit. Suppose I also did arbitration for APDCL, many other organizations. So we quote our bill that arbitration will take this much. If you are acceptable, you are acceptable, not. We are not going by your fees. Now, there is already a fee structure for arbitration. That is also there.
No, arbitrators, my lord, fixes up their remuneration nowadays as per the fourth schedule in the arbitration.
Yes.
So that is predetermined. But the advocate fees is not predetermined. Perhaps, my lord, so far as arbitration.
So therefore,
Yes.
in this case, since it is not a regular, you need a special sanction.
Therefore,
They need a special sanction.
sanction.
Now, special sanction proposal has been granted.
No, my lord, it was moved to the finance
Moved
department on, my lord, 25th of June 2024. On the last date when this matter came up before this honorable court, lordship, my lord, directed me to take the instruction. Accordingly, I took instructions, and it was found, my lord, that they have not, my lord, furnished all the required papers to the finance department to arrive at a conclusion. I mean to say, my lord, more particularly the, my lord, authenticated bills raised by the advocate concerned. It was not forwarded to the finance department, so they could not reconcile, my lord. Now, my lord, that was
Now,
the.
the ball is in your court.
No, now, my lord, he has taken yesterday, they have now again said, it is yesterday. Now I have just taken updated instructions from my department. They say they have received it today because nowadays it is online. So they have received it today. They are now processing. So matter stands in that position.
Okay. Mr. Bapujari has received instruction in terms of this court's order dated 6/9/2024. Such instruction suggests that while sending there were certain defects in FS proposal, which was forwarded to the finance department on 25/06/2024.
My lord.
And in the meantime, on objection of the finance department, same has been rectified and again forwarded on 10th of
I have received it today.
10th, and which has 10th of November, October, September 2024, which has been received in the finance department today only. Full stop. In the aforesaid backdrop, Mr. Bapujari submits that it may take some time to complete, to grant the, sanction the proposal, sanction the proposal, and accordingly matter may be adjourned. Prayer is allowed. As the matter is proceeding in right direction, prayer stands allowed. List this matter.
Next week, my lord, perhaps, my lord, it will be done. My lord,
Before puja.
my lord, next week itself, this month itself.
So that these people can have.
Yes, my lord, today is 11. Can it be on my lord 18th, my lord?
18th of
Next Wednesday.
18th.
I am persuading the authorities, my lord.
Even my lord, even I also want that, my lord. The moment I came to know about this,
Yeah.
I called the commissioner and I looked at you. Meet the queries and send it back.
We wish that this promptness shall happen in case of pension, area of salary of other citizens also who are in the queue.
So we say, all of
These
us
are
are
these are
sailing in
privileged.
the same boat.
These are privileged
My
class. The courts also give them preference. The lawyers also wants to support them. But what about this? The person in the last in the queue. Yes, next, yes.
Matter, your lordship.
Mm,
Lordship, the matter is lordship, without following the land acquisition process, lordship, the
mm.
respondent authority started implementing the scheme. lordship.
Although in the last occasion, your lordship had stayed the matter
Mm.
regarding the land acquisition. Lordship, we have filed an IA for vacating of the stay application. Stay.
Yes, tell us. No, their case is that they are requesting you, you are not
Yes, Lord.
acquiring the land. So therefore, an important project is stayed.
We have filed affidavit, my lord, by district
So
commissioner.
your stand is that this is a patta land. Okay, fine.
Yes, Patal.
In view of that, we said if it is a patta land, how can a person be thrown away for this construction of some dike or something like that?
Yes.
At the same time, we cannot be also oblivious of the fact that this is an important project. Now, they are alleging against you that we are writing time and again to acquire this land and you are not taking any measures.
Here, we have stated in paragraph 7 of our affidavit, my lord, which was filed probably on 11/6/2024. There, my lord, we have stated that no correspondence received from the executing department for land acquisition.
That is yours then.
My lord.
Lordship, we have annexed the letters also.
Give a copy to her.
Ready to
I
issue.
will, I will.
Give a copy to her. And if necessary, if it is an urgency is there, if urgency is there are urgency clauses, pay them and take. There are provisions of requisition.
Yes, Lordship.
Take it, give the requisition fee till it is acquired, make an assessment, but you cannot throw out somebody in the street for the purpose of development without following due process. We'll have to balance.
Specifically stated that no proposal has been received from the executing department.
Okay, take down.
Paragraph 7.
You write, which is the order we have stated, which order?
Lordship ordered in 2824.
2824. In WPC?
WPC, Lordship.
In IA number.
IA 1964 of 2024.
1964. Okay.
Aye.
Avni, you just write down their names. Then paragraph 2, 3 of order dated 28/2024. Paragraph 2, I will correct it later on. 2, 3, 4. Full stop. 5. 5. Then 6. I'll change it later on. Full stop. Then after paragraph 6, then the present application is filed for you file it, you write it. Your IA is Mr. Das.
Lordship,
IA number
2755.
275. This order will be in 2755, huh? And you take these paragraphs from IA 1964. Okay, up to paragraph 6. Such interim order is the present application is filed seeking modification of the aforesaid order, expressing that it is it involves important public project. Full stop. A specific stand has been taken by the requiring department that, where is that paragraph?
Lordship,
Paragraph where you have said we were writing the deputy commissioner?
right, the deputy
Yes.
Lordship, this one is, no, three is the 6, 4, 5.
No, that you have written to deputy commissioner.
Yes, Lordship, paragraph 4, paragraph 5, paragraph 6. Letters were annexed in paragraph 5. 7 also, Lordship.
Hmm.
3, 4, 5, 6, and 7.
Space.
In our IA, Lordship.
In your IA.
IA page. Paragraph 3 is in page number 10. That is the land availability certificates. Paragraph 3. We have
You also do not dispute that lease is patta land.
Yes, Lordship.
Yes.
Patta land, Lordship.
And you also say that there will be damage to them. Therefore,
Yes.
you want a
Yes.
a specific stand has been taken by the requiring department that the project is having us project is a very
Important. nature.
important project
Yes, Lordship.
in as much as it is construction of road come dike,
Dike is important, Lordship,
road come dike.
to protect them. village.
According to Mr. Land Standing Council, the dike is more important for protection of
Of
the
the-
nearby protection of the
Nearby village.
nearby villagers from flood and
Lordship.
erosion, flood and erosion. However, at the same time, it is the contention of the requiring department that construction of said road and dike will definitely damage the valuables, including the houses of the petitioner, and therefore the requiring department has already written to the deputy commissioner to initiate process of land acquisition. Where is that, or where is the by communication there? According to
No, আমি এটাই লিখি।
where is that?
Copy of the application that is later dated.
Page 9, na?
Lordship. Page from page 11, Lordship, that is the copies of the application dated 6/2/23, 14/3/23, 24/3/23, then 18/12/23. Next page, page 12.
Page 12,
Lordship, page, starting from page 11, Lordship,
page 11,
Lordship,
paragraph 4.
paragraph 5. Paragraph 4 is also there, but
I
more
said they say council will not only destroy the Vitellans crop, the trees petitioner, but also will heavily affect the houses of the applicants. This
yes.
which petition I am reading?
IA.
IA?
2755 of 2020.
If I'm reading something different, 2755. Yes, that's right. Paragraph?
Paragraph 3, we have stated that the land availability certificate which we have received from the circle officer. Paragraph 4, starting from paragraph 4, Lordship.
It is a comma. It is the contention of the department that a joint survey was conducted along with the circle officer, Hailakandi Revenue Circle, and assistant settlement officer, Algapur Circle, and accordingly, a land availability certificate was issued on 23/11/2022. Only on the basis of such land availability certificate, the project was sanctioned. And already 63% of physical progress has been achieved so far. It is a specific contention that the department has also made application before the Deputy Commissioner Hailakandi for demarcation of land available for dike from Boroitoli to confluence of river Katahal by their letter dated 6/2/2023, followed by another letter dated 14/3/2023. It is also their contention that the contractor could not execute the work because for the reason that entire dike is encroached by the encroachers. Thus, from the aforesaid stand, from the stand of the deputy commissioner, stand of the respondent department and the stand of the petitioner are contradictory. On the one hand, the requiring department submits that they have been certified as regards availability of land, and therefore they continued with the project and there are encroachment. At the same time, the deputy commissioner takes a stand that the land of the land where petitioners' houses are standing are patta land. Huh?
Filed in the writ petition on 11. We have enclosed the letter dated 6/2/2023 by the.
So therefore, yes, there.
That, my lord, we have even assessed the, my lord, loss. Your lordship will find it.
Full stop. Full stop. Full stop. Full stop. What is the last line? Welcome. According to the deputy commissioner, according to the deputy commissioner, pursuant to the communication dated. Pursuant to communication dated 6/2/2023 and 14/3/2023 of the department, the deputy commissioner has responded and even has submitted the damage report on damage assessment and the required compensation. However, thereafter also no communication is forthcoming from the respondent department.
No.
Therefore, it could not proceed with the land acquisition.
No, Lordship, in 1812, we have stated in paragraph 6, Lordship may kindly peruse.
Just listen to this. This is your submission.
Yes, Lordship.
Thus, two stands are there. One is that there are encroachment and no acquisition is required. On the other hand, that the land of the petitioners are patta land and therefore that should be liquor. Full stop. You have a demarcation. What road they want, what you want. Okay. In view of the aforesaid.
Lordship, Annexure 7, we have stated 1812. That is page 32. Regarding the letter which I have mentioned before, your Lordship.
See, Mr. Das, very simple.
Lordship.
Let us not dictate anything. You want to make a dike,
Lordship.
you construct it. We have no problem.
Yes.
But you cannot construct it over patta land without due process of law. As
Yes,
simple as that.
Yes, that's it. Lordship.
So your stand is that no land acquisition is required.
No. Land acquisition is required.
So
Lordship.
land acquisition
Without
is
land-
required. But you are saying that there are encroachment and all in your application.
Yes, Lordship. We have.
Then,
stated.
so what is your stand on vote? Your submission is, where is your
Because-
statement that land acquisition is required?
Because we have not received the proper communication from the Deputy Commissioner Hailakandi, whether that land is a government patta land or this one government land, because we have received the land acquisition availability certificate, which we have already.
They say that we have already given you that this is the assessment.
If that be so, then Lordship may kindly peruse it.
Huh?
Then
That we have seen that we have passed the earlier interim order on the basis of the revenue authority.
Lordship.
Because so far relating to the issue of revenue,
Lordship.
we will believe the revenue authority, not you. Because you don't know head and tail of the revenue.
Yes, we know.
You know that I want to construct a road. You do not know where it's a patta land or khas land or land belongs to whom. They are taking a stand that this will go as a patta land. You resolve it.
Yes, we are going to resolve it. but-
Basically, this writ petition is between you and her. So resolve it, come back next week. Okay?
Lordship,
No. From the aforesaid, it is seen that the dispute is relatable dispute basically for miscommunication or non-communication between the
Two departments.
collector as well a collector and the requiring department. Therefore, before vacating this interim order, this court will like like a status report from the deputy commissioner as well as from the applicant
Water Resource Department.
Water Resource Department on the next date fix.
Gotcha.
In the meantime, both the authorities may sit down and resolve the issue and affirm whether the patta land of the petitioner shall be required for the construction of the dike or not. That's all. We'll cut it not on all on the Sunday. Generally, I'll correct it. This is the issue. Sometimes we have doubt also, na? Because yes. The sum and substance to understand what is the challenge.
Challenge is lordship, this is a supply of inpatient diet.
Diet
in
to the
Medical College.
Nagaon Medical College.
There
Okay.
is a jam tender. And the lowest bidder. And that has been declared. I have given the all money, the bank guarantee and everything. Agreement is there. Now they want that the earlier party to continue. So delaying, nothing else, lordship. There is
No
jam
problem.
tender. They cannot do anything. It is and they para, lordship. That is
What
why I
is the
want to
stand
show,
in the
lordship.
affidavit? What
Para
is-
nine, no, 3 times, lordship, they have asked for time.
No, my
No
lord.
affidavit till
My lord,
today.
Okay, now let us just this is overview.
Lordship.
Your case is that after a due process of tender, I have been selected, everything is done, only the work order is to be issued.
Yes.
However, they are continuing with the earlier supplier.
Yeah.
Yes.
Our affidavit is almost ready, my lord, because my lord, the rate quoted by the petitioner is too low, my lord, for a patient, my lord. That is, and because of that reason, my lord, the petitioner was asked to attend the office of the principal, my lord, in the month of August to discuss about the rate, my lord. Because that rate, because the authority feels that in that rate, my lord, it is not possible to supply a nutritious and good meal to the patient, my lord. So that rate is too low, my lord. And and to discuss
Okay,
it,
very good. You enhance your rate.
yes, to discuss it, my lord, it is on record also, my lord. They have been called, petitioner have been called.
You'll be happy. He want to give you at 10 rupees, you want it to be given with new. Okay, he will
Petitioner
maintain.
have been called by the authorities to discuss the matter. He has not turned up, my lord.
Discussion is for enhancement. This is a very
Discussion is
difficult
for the
proposition.
rate, my lord, that
This is the nutritional value, increase of nutritional value is
my
very
lord,
difficult.
discussion for the rate that at such a low rate, how the petitioner can supply it, my lord. So,
Cancel him if he can give non-nutrition
my
food.
lord, let him attend the office, my lord, once, my lord. He has been asked to attend the office, my lord. He is not going, my lord.
Have you seen that the COVID time Dalgona coffee?
Yes, my lord.
We have doubt about that creamy layer of the Dalgona coffee in this negotiation.
Yes.
Understand?
No, my lord, that is not. Because his other contention is that
coffee means there's something different.
The health department and the other medical college, it is 76 rupees, 93 rupees, and my rate is 117. And they said it is a lower price.
Not 117,
And lordship
100,
is-
my lord.
It is 117, lordship.
Okay, we'll say that since we'll say that only this is the only difficulty. So therefore, how much, according to you, what should be the rate?
My lord, he
No,
has
no, tell us, we'll not send it to you.
Because
Tell us.
regarding that, I don't have any instruction, my lord, but he has been asked to.
Put you heavy cost in this regard. What is the present person taking, giving at what rate?
I will obtain instruction, my lord.
Lordship, also, I have the right. Even the present person has taken part in the tender, and there is a difference.
He
that
has
lordship has
taken much
shown.
higher rate than the petitioner.
So you are giving,
No.
what is the existing rate?
Existing rate, I don't have right.
You have it.
Yes.
We are taking it up tomorrow.
Lordship.
No, this is a public money.
Yes, my lord.
if this is a situation that after tender, government is not accepting a lower rate and paying more money, we'll ask you to calculate the amount and the who is responsible, it is be deducted from his salary.
Yes, Lord.
Tomorrow,
Lord,
list this
I'm
matter
getting-
tomorrow.
Can it be day after tomorrow? my
No,
lord?
day after tomorrow, not
Because
possible.
this instruction may require some day after tomorrow, my lord.
You have telephonic instructions. Day after tomorrow, not possible. Then it will go to Tuesday.
Yes, my lord. Tomorrow, lordship. Tuesday, my lord, because the calculation.
Mm. The grievance of the petitioner is that even after the petitioner being declared as L1 tenderer for supply of food, is that it?
Yes, lordship, diet lordship of the inpatient, inpatient diet.
For supplying diet to the inpatients at Nagaon Medical College. And even after completion of all the formalities, the final work order has not been issued to him. Full stop. The present IA is filed with a direction direction that it issue to stay and a communication dated 18/7/2004 issued by the respondent number 4. Respondent number 4, whereby space whereby the
17.
earlier contractor has been asked to continue to supply the diet in the hospital, though the said contractor was not successful in the tender process. Full stop. It is also discernible from the record that the earlier contractor was supplying the diet at the rate of rupees earlier.
Earlier, lordship, the earlier, the what rate lordship, but it is.
Okay, not necessary.
1
Stop.
crore rupees.
Stop, stop,
difference is there.
At this stage, Mr. Bora, learned standing counsel for the health department submits that the work order is not issued to the petitioner for the reason that the petitioner's the rate quoted by the petitioner is too low, and at that rate nutritious food cannot be supplied. First time I have come into this case.
Because there are several complaints regarding the quality of diet in the.
Against,
medical-
without supplying against him.
No, my lord, not against petitioner, my lord.
Then
My
if
lord,
complaints, cancel it.
no, my lord, the quality of the dietary article.
Okay, okay.
them, they are continuing,
It is the further instruction of the learned standing council that that the authorities are having apprehension that at this rate quality food cannot be supplied. Countering such argument, Mr. Sharma, learned counsel, submits that the foods supplied at other hospital like other medical colleges like Guwahati Medical College, etc., are even at lower price than that of the petitioner. Full stop. Be that as it may, as Mr. Bora has sought for an adjournment, prayer is allowed. However, he shall clarify. According to them, what should be the rate at which a nutritious food can be granted, and if that be so, the petitioner may be allowed to enhance his rate and supply the material.
Enhance.
That is your case.
Is there-
That is your case.
Yes, my lord.
Supplied. Full stop. However, this court. Full stop. However, full stop. Let this matter be listed once again on Tuesday next.
18th, my lord, because this order I will communicate to the principal, so it takes 1 or 2 days, my lord, on 18th.
What
my-
1 day? It is a WhatsApp.
My lord, exactly what your lordship had indicated, it will be easier for me to communicate with the order, my
You
lord.
will get it by 4:30.
Yes, my, on 18th, my lord, kindly on
18th
18th,
is 18th is what date?
Wednesday, my lord,
Okay, on 18th.
18th.
Please, your lordship, the matter pertains to non-disbursement of working capital subsidy and power subsidy. In fact, lordship, the predecessor of the petitioner, lordship, he was a proprietor of Messrs United Bakers, and he carry on mechanized manufacturing of biscuits. And lordship, under the industrial policy of Assam 1986, eligibility certificate was issued by Udyot Sahayak for claiming both the subsidy. Lordship may.
According to him, this was sanctioned and all.
Yes, yes.
Lordship, it was not sanctioned because I have filed an affidavit. In the affidavit, I have annexed the DLC minutes. In the DLC minute, it has been discussed and it was not considered because at that point of time, the bill was not, because it was an electricity bill. So electricity bill was not paid. So this is, I have filed an affidavit here. Lordship, I kindly find an affidavit.
Lordship, before my other side, responsibility. In fact, this affidavit which they have filed, lordship, it contains lordship untrue statement, lordship. They are in fact making false statement because the documents which they have annexed, the minus, it say otherwise. It say
Let us
both of my claims.
Let us see, where is the minus?
I mean, I don't know why he said it's a false and like misleading statement. Because this is very clear, language is very clear.
Let him understand why he's saying yes, you are good.
Yes, if lordship takes to lordship, just my read petition, page, I'm taking to page, 11, Annex 3, lordship. Lordship might have got it.
Yes.
May I just read, lordship? With reference to the above, I would like to inform you that district level committee in its meeting held on 1/3/2007 has recommended 41,989 on working capital subsidy for the period from March 88 to March 91 in respect of your unit. The amount will be released when we receive sufficient fund from the government. Lordship, this is with regard to the working capital subsidy. Lordship, the next page, 12,
Now, what is their stand as regards to which two documents?
Lordship, their minutes say that both by subsidy.
You have made a statement in the petition that these are the documents by which I was informed that my subsidies are sanctioned.
Yes, lordship.
What is their stand as regards these two affidavits?
As regard to this stand, their stand is that, in the affidavit, they have stated that my power subsidy was not, approved by the district.
No, what do you say? Do they rezone these two documents?
In fact, lordship, if lordship goes to the affidavit, the documents which they have annexed, it say otherwise, contrary to.
No, we'll come to that. We'll come, that we do you have understood? According to you, the documents itself, the minutes of the meeting itself says that recommendation was made. That we understand. What I am asking is, you rely on your case on two documents.
Yes,
one is 27 July 2007 and other is 17th of September 2007. According to it, you were intimated by the general manager as regards sanctioning of recommendation of power subsidy and what is other is called?
There is lordship,
Capital subsidy. So capital subsidy and power subsidy, according to you have been informed that we have sanctioned it. What is their stand in the affidavit as regards these two documents?
That's what I am stating, lordship. In the affidavit, they have stated that my power subsidy was not even.
Okay, where is that? I am asking something different. Do they rezone this or they admit these documents or give some explanation that this general manager issued, not issued?
If lordship goes to the minutes, which they have annexed, lordship, that's what I.
What is your stand regarding these two documents?
As far as the first document is concerned, let's say we agree to that, we admit that.
Okay,
And
you
in fact, the amount was sanctioned and they have been asked to submit certain documents. They have not submitted those documents.
According
So the money was returned.
No, that will come to later.
Correct.
What about the document 17/9/2007? Do you admit that it was intimated to him by your general manager?
No, that is the controversy is with regarding this only. Like what has happened is that in the minutes of the meeting, that has been rejected. That has not been considered. But why this letter has gone from the general manager, that instruction I could not get it because.
No, what is your affidavit? Forget about the instruction. What is your stand in the affidavit regarding these two documents?
As far as the first document is fine, second document we are denying it.
So we are,
That we want you.
we are saying it that like this minutes of the meeting, in fact, rejected it. So there is no, I mean, like, there is no, point of like, I mean, like admitting this because on the face of the minutes of the meeting, it has been rejected.
Lordship, I'm just Lordship advancing what my learned friend had said, Lordship. If Lordship takes.
Let me first advance something.
Lordship.
Then I will go to your advancement.
May I take a lordship with the minutes of the meeting?
No, we'll go to the minutes later on. See, 2 communications has been issued by general manager. On the basis of this, a petitioner has come and said that this is the information given to me.
Correct, Lordship.
Many things may happen that
Correct.
this is a bogus document. And may happen that in fact there was a resolution, it was intimated to him, you have manufactured the subsequent document. So your stand regarding these 2 documents are very important.
I understand, Lordship. Fully agree with,
That's
you.
why, so we
Fully
cannot,
agree with that, Lordship.
and he is not understanding that.
Fully agree with this.
Lordship, I deeply apologize, Lordship.
Your whole case really rests on this.
Lordship, I deeply apologize.
Where is your statement regarding these 2 documents?
Lordship will find it page 7, sorry, page 4.
Paragraph 5.
Paragraph 5.
What is your reply to paragraph?
Paragraph 7, your Lordship. Reply to 5 is paragraph 7. May I read out, Lordship? That with regard to the statements made in paragraph 5 of the writ petition, the answering deponent denies that the district level committee has ever approved the claim of the petitioner regarding power subsidy of rupees 1,20,564 for the period from 31/10/2090 to 1990 to 31/1/1991. In this connection, the answering deponent states that the district level committee has gone through the application of the petitioner for the power subsidy for the period 31/10/1990 to 31/1/1991 under the industrial policy of.
Okay, now show us the my minutes.
Minutes of the meeting, Lordship will find it page, it starts from page 9.
Of the writ petition?
Yeah, no, Lordship, that affidavit. So it was dated on 1st of March 2007. On the
Okay.
top of it, top of the letter, top of the minutes,
Okay, where is the minutes?
that page 10, Lordship will find the relevant part.
Yes.
The third paragraph, your Lordship. Third paragraph, the committee also goes to the application of United Bakers, the petitioner, for power subsidy for period 31/10/1990 to 31/1/1991 under 1986 industrial policy, the period of which did not consider at the term of application of the units 4/2/2092. The said period of claim kept pending for non-payment of ACB bill by the units due to stay order of the Honorable High Court against the disconnection notice served by the ACB. The unit has already received full amounts of power subsidy with effect from 21/1/87 to 1/1/1992 under 1986 IP, except the period of the present claim. So this was not considered because there was a case going on, and they have given, they have filed a rejoinder, Lordship. In the rejoinder, they have stated that they have settled it. But like settlement documents are not given, and those documents are not intimated to the department, not given to the department. So this minutia is very
What
clear.
about capital subsidy?
That is clear, that is clear, that has been admitted, Lordship. That Lordship will find at page 11, your Lordship.
Lordship, since my friend had just
Just a
Lordship
minute, just a
interfered-
minute, just a
Lordship,
minute,
Just a
just a
minute,
minute,
next
brother,
paragraph,
just a
Lordship.
minute.
Yes.
So page 11. So 11 United Bakers. So amount recommended as interest subsidy 41,989.
Where? Page 11?
Page 11. That's but for first paragraph, you always say first.
Feasibility of study cost subsidy, state capital invest subsidy.
Yes, Lordship.
Messrs Eastern, SS Food.
No, the United Bakers, Lordship. Page 11,
Page 11.
United Bakers. On the top.
United Bakers, Lokra, yes.
Yes. So amount recommended, the last line.
So have you paid this amount?
That's what, Lordship, what has happened is that, like, I mean, this amount was sanctioned. Then we sought for certain documents. This is a mandatory, certain document has to be submitted while disbursing the money.
Yes.
So like that letter is there, Lordship will find at page 12. Page 12. So we have written to them asking for these documents.
And what they say now?
So they have not submitted these documents, so that's why what has happened, Lordship, page 13, your Lordship will find.
Hmm.
All these amounts has been sent back, returned, unutilized, because they haven't submitted those documents. Page 13, Lordship will find. And their name will, Lordship will find it page serial number 12, your Lordship, serial number 12.
Okay.
So this is the status. Yes.
Lordship, the minutes, Lordship, page 10, Lordship, my colleague has read the third paragraph.
Okay.
Lordship, fourth paragraph is very important, Lordship.
Paragraph,
I'm just
yes.
reading.
Page?
Page 10, Lordship, of the affidavit filed by the respondent.
Page 10.
Page 10.
Hmm.
Third paragraph, Your Honor, my colleague has, Your Honor, read over, Your Honor.
The committee scrutinized the
Yes.
previous claim.
The committee scrutinized the previous claim of the unit and order passed by the Honorable High Court and decided to consider the leftover period of PS power subsidy claim and has recommended the eligibility amount as per policy guidelines. That
fine.
was approved because it was approved by the Your Honor, district level committee. The director of Your Honor, industry has communicated me.
Why
giving
power
reference.
subsidy is given?
Lordship, because the traffic rate is very high, Lordship.
So power subsidy is
Lordship.
given. Here, what could we understand is to give you power subsidy, you will have to use power and pay bills. This is not in advance. You pay the bill, you submit it, and you are given subsidy. In this case, for non-payment of your bill, it was your connection was disconnected.
Lordship.
Now the High Court passes and stay order.
Lordship.
You continued, but you did not pay any bill, and you did not submit. So from on which they will give you subsidy.
Lordship, my respectful submission, Lordship. Before Lordship, the matter was placed before the district level committee. We have Lordship in our rejoinder, Lordship, a reply against the affidavit in opposition, Lordship. We have annexed the very document, Lordship. Page 5, Lordship, that we have.
Now that money is returned back, what can we do?
Lordship has to, Your Honor, direct them.
Difficult. So ye show us your
Yes.
affidavit.
Lordship, relevant document, Lordship. We find at page, Your Honor, 5 of my, Your Honor,
Yes.
reply, Your Honor, that the matter was settled with the, Your Honor, ACB, Your Honor. This is an, Your Honor, OTS scheme, Your Honor, which I have settled. It was settled long back, Lordship, and even I have intimated this to the, Your Honor, the concerned department.
Proposal, your Lordship.
You know, may I just read, Your Honor? One time a settlement of dues with reference to the above, I am directed to inform you that the appeal for one-time settlement.
Where
of
is
the-
that you have paid this and it was settled?
Yes, Lordship.
Lordship, we have paid the amount because
That is what they are saying. Please give us the proof we are giving you.
Lordship, otherwise, because the very minute, if Lordship goes the second portion of the minute.
I've seen that.
Because
What is the minus is that recommended.
recommend.
But what will it cannot money cannot be paid on air. The subsidy is for the purpose that okay, you continue, you pay the bill, but we'll reimburse something because rate is high. So that reimbursement can be made subject to you paying the amount.
Lordship, my respectful submission, Lordship, in their affidavit, they had stated that once, Your Honor, the matter is recommended and approved by the, Your Honor, district.
What is the amount? How it will be paid?
Your Honor, I have.
Can we say that, okay, since you have paid, whether you have used electricity or not, pay it. This is a public money.
Lordship, I paid the dues because right
is
now,
that?
Lordship, I do not have any record because the petitioner, he expired. Whether his
That cannot be a ground.
whether his legal heirs will be able to, you know, furnish those documents, you know, I do not have, but I have to obtain himself. But Lordship, if Lordship goes through the, Your Honor, their own, Your Honor, affidavit, which have filed in page number, Your Honor, paragraph 5, Your Honor, they have stated that once the matter is approved by the district level committee, they have to disburse it. And my, Your Honor, subsidy was
They will
approved.
disburse is no problem. They have seen that this industry is entitled for capital subsidy.
Lordship,
So recommended. Now they have recommended. The executing authority will say, okay, give your bill. This is 10 lakhs, your electricity bill. So 25% will be subsidy. 2.5 lakhs, you are refunded.
Lordship, already when I have made my application, I have annexed all the documents. Subsequently, Lordship, I need not have to give any other documents.
The
because-
recommendation itself says that it has no dispute that bill was not paid. It was no dispute that there was a stay. There is no dispute that you have not paid.
Lordship, I admit for the second portion, they have approved because.
And it is also on record that there was a proposal for settlement on such and such amount.
Lordship,
Whether that has been settled is not before us.
Lordship, just, Lordship.
Hope should end one day. Let
Lordship,
us
in
close
fact,
this. Let us close this today.
Lordship,
Isn't it?
Lordship.
Hard. You are Mr.
Jida.
G. Das, Learned Counsel for the petitioner. The present writ petition is filed claiming interest subsidy and power subsidy amounting to rupees 41,989 and rupees 120,564 respectively. Full stop. It is the case of the petitioner that such subsidy was approved by the district level committee in its meeting held on 1/3/2007. However, such amount has not been paid to the petitioner till date. Full stop. The petitioner relies in support of such contention. The Learned Counsel for the petitioner refers to Annexure 3 communication and Annexure 4 communication issued by General Manager, District Industries and Commerce Center, Kamrup, whereby it was intimated to the petitioner that the district level committee in its meeting held on 1/3/2007 has recommended payment of rupees 41,989.00 on working capital subsidy for the period from March 1988 to March 1991 and recommended and in the said meeting recommended payment of rupees 120,560 as power subsidy for period with effect from 31/10/90 to 31/1/1991. Full stop. The respondent, Industries and Commerce Department has filed an affidavit wherein they have brought in the minutes of the meeting dated 1/3, what was the date?
1/3/2007.
1/3/2007, isn't it?
Yes, 2007.
2007. So far relating to the interest subsidy, it is seen that an amount of rupees 41,989 was recommended in favor of the petitioner by the said committee. It is the stand of the respondent authority that a communication was issued to the petitioner why this amount was not paid?
If this amount was allocated, then we have intimated them that certain documents has to be submitted. Those documents were not submitted by them. So the amounts were returned back. So that letter is also there at page 13 here.
Lordship, in fact, we never received this letter, Lordship. It's just a ploy. Lordship. I have taken a specific stand, Your Honor.
We have written to them in 28/2014 and the whole amount, and like along with them, a lot of other units also, they have also did not submit.
By a communication dated 28/2014, a request was made to the petitioner to submit certain documents for release of the amount already recommended. The respondent authorities has it is contended by the respondent authorities that as no materials / documents were submitted by the petitioner and some similarly situated organizations, the the amounts, the checks were cancelled and the request was made to the bank to cancel the banker checks by which the money was supposed to be transferred to the beneficiaries. Accordingly, the said money, said banker checks has already been cancelled. This money comes from whom?
Lordship, this is there. I mean, there is a government head account is there. So cancellation of banker check and deposit the amount to government head 285.
And accordingly, said amount issued in favor of for which banker checks were issued in favor of different beneficiaries were deposited in the account of in the government head.
It were cancelled and then deposited.
Full stop. Full stop. Therefore, Mr. Kalita, Learned Standing Counsel, argues that in view of the aforesaid, the right of the petitioner has extinguished and a writ cannot be issued as on date for reimbursement of the such amount at this belated stage. And there shall not be any possibility of payment of such subsidy at this stage. So far relating to the electricity subsidy, the minutes of the committee dated so reflects that no subsidy was specified or earmarked against the petitioner as for the reason that the disconnection of the electricity of the unit of the petitioner's unit was a subject matter of dispute in a writ proceeding, inasmuch as from the record it is discernible that the Assam State Electricity Board sought to disconnect the petitioner the electricity connection to the petitioner's unit for non-payment of bills. Therefore, according to the stand of the industries department, such payment could not be made in absence of payment made against electricity to the ASEB. Though the learned counsel for the petitioner has projected that the dispute with the electricity has been resolved, however, the Annexure 8 annexed to the additional affidavit only shows that there was a proposal of settlement between by the additional chief engineer ASEB on 4/8/2004. However, there is nothing on record to show that such proposal was finalized and the petitioner had paid the amount so that he can be disbursed the electrical subsidy. Therefore, considering the stand of the respondent that for want of sufficient material, the subsidy cannot be granted, this court do not find any arbitrariness in such action of the petitioner, of the respondent state. Arbitrariness, full stop. Therefore, in absence of any arbitrariness and violations of the petitioner's right, this court cannot issue a writ of mandamus to pay the capital subsidy relatable to a year to the year of 1991 to the year of
Just a minute.
for the period 31/10/90
Yes.
to 31/1 1991. And for full stop. This court also cannot find fault with the Industries Department in non-disbursing the electricity service, electricity subsidy for want of particulars and proof, more particularly.
That is interest subsidy.
No, that is interested. Now I'm coming to this. So far relating to the electricity subsidy, this court cannot also find fault with the respondent authorities, more particularly when no proof was available before the authority as regards the factum of payment of electricity by the petitioner's unit to the electricity board so as to calculate the subsidy and pay thereof. Inasmuch as it is a condition precedent under the scheme to grant a subsidy when the electricity is consumed and payment is made. Full stop. In view of the aforesaid, this court finds no illegality in the action of the respondent state. Accordingly, the writ petition stands dismissed.
Obliged.
Mr. Gogoi, when this other matter regarding CBI inquiry and all we have fixed? 26th. Mr. Mahajan, you are waiting for that case. That today. You will like to argue, isn't it?
No, Lordship, argument is not necessary.
Having the same bill.
Argument is not necessary, Lordship. Just I pointed two things, two more.
You want an CBI?
Three things, Lordship,
Okay, fine. Okay, continue. Yes.
Lordship, kindly see the last order of the Honorable Court, Lordship. Here it appears from the affidavit filed at the respondent number 3.
You have been paid.
Lordship, but that is not the actual amount for transportation charges. Actual amount is, Lordship, 13 lakhs 58,000 55. Sorry, 13 lakhs 58,000 553 rupees.
What is that?
20. That is reflected in my prayer, Lordship, at page 14.
Yes.
It is 14 of my writ petition, Lordship.
Now, affidavit file.
Hi, Malad.
What is your stand?
We have stated that we have already paid the amount, Malad, 46,099 rupees, Malad.
Do you say that this is actual amount is
This is the actual
Where
amount.
is your stand?
That is, Lordship.
Kindly see at page 49 also. At page 49.
49 of what?
Serial number 6. Hilamara Samabai Samiti Limited. Grand total of each society 13 lakhs 58,553 rupees.
Page 2, sir.
Page 49.
You have made statement in which paragraph regarding this? Your statement in your writ petition that you are entitled for.
In prayer.
No, prayer in the affidavit in the main body of the petition.
In the main body of the petition.
Where have you stated that this is the amount due?
This is not amount due, Malad. This is Gaon Panchayat Samobai Samiti. It's not Hilamara Gaon Panchayat, Malad. It's a
Lordship,
total amount.
it is 49, Lordship, it's serial number 6 may kindly be seen, Lordship.
Please show us in your writ petition saying that this is the subsidy or whatsoever due to us. Then we'll see what is their stand in the affidavit. As simple as that. That is vital. Nobody is prepared with their briefs.
See, in Annexer 6, 8 page 79, and a representation submitted by the secretary regarding supply of rice. Annexer C may kindly be similar. Annexer 6, page 79.
This is difficult. Where have you stated that this is how we are entitled? Where is your affidavit? Now, no statement is there in the main petition. That this is due, this is, we have transported from this simply in the prayer. How can we say? Where is your affidavit?
My lord,
Lordship, I have not got your affidavit.
affidavit has gone. My lord, in our affidavit, my lord, though its running page is not here, my lord, page 3 of our affidavit, my lord, 7, paragraph 7 and 8, my lord.
Lordship, in my read petition, 8 page 10 may kindly be seen. Lord.
Page 10.
Page 10. Para 11.
Page 10.
Page 10,
Hmm.
paragraph number 11. Date, may I read, Lordship? Paragraph 11, date on 10th of January 2014, Sri Babu Soikia, Chairman of Bhagwakhana Samavai Samiti Limited, submitted a representation to the Deputy Commissioner Lakhimpur stating that
What is their reply to this statement?
Paragraph 11, my lord. Paragraph 11, my lord. No comment, my lord.
See.
My lord, this is, as I understood, my lord, this is by the Secretary and President of Dhokwakhana Gaon Panchayat Samavai Samiti.
This is
Limited.
Dhokwakhana only.
It is, man, they are, my lord, Ghilamara Samavai Samiti.
They are Ghilamara.
Under my lord, Dhokwakhana.
under Dhokwakhana,
So, my lord, it's a, for the entire area, my lord, for the Dhokwakhana Gaon Panchayat, my lord, for the whole Gaon Panchayat, my lord. Total amount.
What is the name of this?
Ghilamara Samavai
Committee. 8 page 49, Lordship.
Nothing is there in this. Whether Ghilamara is under Dhokwakhana's Samavai Samiti. Because you are saying about Dhokwakhana.
Yes.
Under Dhokwakhana subdivision, it is.
But this is the total amount, my lord, which they require, my lord.
No, total amount is 89,13,377. According to them, an amount of 13,58,553 belongs to them.
That's according to them, but my lord,
What is your stand?
we have already stated.
You have not stated that, no. Say that.
Yes.
Lordship,
It is a claim has been made in the present writ petition that the petitioner society is entitled for an amount of rupees 13,58,553.20 against transportation. What do you call it?
Transportation charges.
Transportation charges.
Transportation charge. my lord.
Actual transportation.
As transportation charge.
Charge of
Full stop.
rights.
The respondent has filed an affidavit and has submitted that the petitioner Samavai Samiti has received an amount of rupees 46,099.00 as transportation charges for the period October 2010 to March 2011. The Learned Council submits that the actual due to the petitioner is 13,58,553.20. However, nothing is discernible from the writ petition that how they have arrived at such calculation and the period thereof. Where is the period? Full stop. In view of the aforesaid, the MSU, thus Learned Council, is permitted to take an instruction from her client as regards the actual amount due to the petitioner society and whether any outstanding due is there as on date after payment of rupees 46099.00 for the period October 2010 to March 2011. Is that it? Your period, your claim is?
Lordship,
You also
they
do not-
have been
What
stopped.
is your, please, madam, tell us. We'll dismiss it right now. What is your claim of transportation subsidy? Period.
It is
Which period?
2008.
Where is your statement?
From 2008 to 2013, Lordship.
It is,
Till today.
Paragraph 5, my lord, they have said.
paragraph?
5,
Is it the way to file a petition? Paragraph?
5, my lord, they have stated. Till today, my lord.
September 2008 till today, Lordship.
Any outstanding
From
due
the
is
March
there
of September.
since in for the year since 2008, September 2008 till
Lordship.
the payment made, payment purportedly made to the society amounting to rupees 46099.00 as reflected in the affidavit filed by the respondent.
In the affidavit, my lord, paragraph 8, we have stated the entire amount since September 8 to March 15, we have paid. And I'll
No-
take the,
no,
my lord,
Lordship.
paragraph 8 of my
Actual
affidavit,
amount
my lord.
is 13 lakhs.
Yes, correct. That we have.
Where have you said? Then we'll close it. Tell us.
Paragraph 8, page 3 of our affidavit, my lord.
Where is that?
Paragraph 8, my lord, that the deponent begs to state that transportation charge of AOY rice since September 8 to March 15 has already been paid to the petitioner. Has your lordship got it, my lord?
Lordship, we have not
Paragraph
received
8,
their
page 3.
affidavit, Lordship.
Oh, running this nine, but straight out, I say. Yes.
Where do you get that as regards?
My lord, page 8 of page three-
Paragraph 7.
Paragraph 7, next paragraph 8, my lord, that has already been paid to the petitioner, my lord.
A specific stand has been taken by the respondent state that the transportation charge from since September 2008 to March 2015 had already been paid to the petitioner. Full stop. However, no reply affidavit has been filed, though a verbal
Got your affidavit, Lordship.
submission is made that
Without filing, we can't file.
Kindly 2 weeks time may be given for reply, Lordship.
received by Sam Soikia on 14/11/2019. Affidavit.
Lordship, what reply?
RC Soikia.
Lordship, but in this file,
You
it's
do not
not
know?
available, Lordship. Kindly 1 week time may be given,
In
Lordship,
view of
for
the
reply.
aforesaid, the learned counsel for the petitioner is granted a 2 weeks time to obtain instruction and to file a reply affidavit if so advised.
Oblige.
The lordship direction was I have gone to the CD lordship and make a note lordship. The admitted fake serious less and carelessness is there lordship.
So therefore, if we want to appoint CBI or whatsoever, if you say Kailash, I cannot write it is Kailash, therefore CBI. A judge is to give its reason.
Lordship, lordship.
These are the principle of law. Why, these are the facts, why we want to give it. So for that purpose, we have fixed another matter
Lordship,
on
we have
when the
26.
legal deliberation will be there so that we can record.
Otherwise,
So we thought we'll get the help of Mr. Mahajan, and that case is there on 26. 26.
otherwise lordship, I'm proposing so. Otherwise lordship is admitted fact of the record lordship. There is a
No, I
serious.
understand. We have full faith on you. You will not tell a lie.
There is a serious lapse lordship. It is after going to the CD lordship.
So therefore, we will
I
have
have
to
never
write that
seen
these
such
are the
type of-
lapses
Well,
and
can
these
I-
are the
can I-
principles
Lordship
of
is
law.
correct.
Like,
For that, my lord.
instead of CIB,
One
CBI
reason.
lordship, instead of CBI lordship, I proposes lordship It can be by the CID of Assam also.
With that will decide, that will decide.
Whatever agency, my lord, that I will leave it to your lordship, my lord. Yeah, my lord, of course, my lord, lordship may fix it together also. Otherwise also, my lord, the lapses are this, my lord, to be very paramount, my
No,
lord.
we'll take up on that matter. You have also gone through it.
I have not gone, but he has gone
Got
through
it?
it thoroughly, my lord.
Okay, give a note which are the lapses of the record.
Of the record, no,
Of
just,
the record.
just lordship, just look.
Okay, keep it there.
That's the-
Why I'm proposing is, since we are hearing similar matter on 26th,
Fine.
we will not waste time.
My lord, my lord, your
But
lordship
in
prefers.
Same argument will be
in
there,
res-
the principle.
26 is my case, my lord.
No, no,
Some other case.
Oh, I'm sorry, my lord.
So therefore, we want to hear this
Yes, yes,
case both together,
Yes.
because ultimately we'll have to record what is the principle of law in doing.
No, I
and
have
what are-
understood, my lord. My lord, it has to go to some other agency because Apex Court is also recently very clear
No, that we
that it
understand.
cannot go to the same agency,
But
my lord.
advantage of Mr. Mahajan and Mr. Gogoi is that they can just say that this is the principle of,
lordship has to write it down.
this is principle of law, so that can be given.
Even lordship,
But
last,
even if you give a, both give a consensus, then also I will have to,
that procedure law part.
we will have to say,
Even lordship-
first that this is the petitioner's case, this is the settled proposition of law, this is the
Mine.
difficulty. So that's why I fixed the matter on 26th, I think. So at least that will be on 6th.
Even lordship, just look out, otherwise what?
Yes,
What
this will help me the working on the previous night when matter will be listed.
And what lordship has said, lordship, it was already last Friday, honorable Apex Court three judges bench has said that the principles, lordship, regarding on what ground and what purpose we can send it to other agency.
He is very correct.
Other agency, lordship.
So that
He has done his homework pretty well, better than me, my lord.
So he is also in the other case.
My lord.
So that's why, and that
Other
CD
case-
is, he's, no, other case,
Lordship, lordship.
that is a different
Lost,
issue.
lost.
In which case, what will you
Lost,
will pass,
lost,
that is a
lost,
different,
But
but
factual method.
factual matter.
Lordship, lordship.
As agreed to by the parties, list this matter on
26, lordship, that matter on 26, 9. lordship.
26 is a difficult
26,
proposition.
when lordship says, fix so many matters, that the lordship.
I'll have to travel second half difficult, 26, no? It's Thursday, 27th is April. Okay, Thursday will be
Lordship, lordship.
26.
26.
Highly obliged. Thank you.
Obliged.
Highly obliged.
Six.
I think so, lordship.
Yes,
Lordship, in this case, my lord, do-
admittedly, he was skilled, affidavit is there, so give some similar orders. What is the, where is the scheme?
but my lord,
Hard.
today I have got in,
Hard.
instruction, my lord.
Mr. M.R. Khandokar, learned counsel for the petitioner.
My lord, 1 minute, my lord. Today I got get instruction, my lord, the District Legal Service Authority already passed an order of 5 lakhs.
So it is in fact, sir.
Maybe
Learned counsel for the petitioner submits that as the District Legal Services Authority has already passed some orders granting compensation to the petitioner, nothing survives to be adjudicated in the present instance. Accordingly, the writ petition stands closed, being in process.
Pass. Five disaster management. Seven.
May I please, lords?
Where is your, from where are you saying that it is 35 feet?
This is my, the parcel that has been
Show us.
allotted. Kindly come to page 38.
Page
And
30,
tertiary part is the page 30, starts from 36.
30?
And 36 is the tertiary copy, English tertiary copy. And the number 5 at page 37.
37. Disaster. 37.
Where is the original of the patta?
Next page. 30.
Where is that provision? Which, where?
Number 5. আলী মেরামত কৰিবৰ নিমিত্তে ৰাজ্য চৰকাৰে বা ৰাজ্য চৰকাৰৰ কাৰ্যকাল সকলে কোনো লোকচানী নিদিয়াকৈ সকলো
That we understand. Now, what is your stand 66 feet?
But that we have stated, my lord.
Hmm.
That is, my lord, page, paragraph 17 at page 4, my lord, running page. my lord.
Paragraph?
Paragraph 17. Page 14 of our application. As your lordship got, my lord, filed on 21st of June 2017, my lord.
Pace?
Page 4 of our affidavit,
Okay,
my lord,
okay, okay.
filed on
Okay.
1st of 21st
Okay,
of June.
page 4. Paragraph?
17, my lord, for
14.
14 also,
Yes.
14, my lord, yes. So the record set revenue, my center for the range, but the raise from the distance from center to the little road.
This statement was prepared when? When the patta was granted to you?
73.
70?
3.
My lord,
But in 69 map, it is said 66 feet.
66 feet. my lord. Asa.
I rely on my patta.
Which will have precedent? Your patta or their settlement record?
My patta is not of my own alone. Resource survey. Now, this is as per the order I have received, and I've been enjoying this part since 73. Now, if it is there, then the preparation of this patta, I cannot say it is the wrong one because there is been there.
No, we cannot say preparation is wrong. But on the date of preparation of the patta, already was earmarked as 66 feet.
Both the records are with them.
Hmm.
But I've been provided with, and I'm not only me like other persons also granted that part. Now, if they say that we do not, it's specific in para 17, they're stating that the reason of reservation up to 30 is not known. Come to page 4, 17.
I've seen it, I've
Is
seen
it
it.
not known,
They
but
even
my
do
lord,
not know how it is. Now,
but same was drawn during my lord last settlement operation in that 69-70, my lord.
Your statements are based on knowledge.
yeah,
Produce the record.
I've said that part. And now, whatever I mean on record, they in my reply have stated that all paragraph they have accepted, admitted.
No, that they have admitted that you are a patta holder, your land is taken, that portion is taken.
Yeah.
But their whole case is that this is a land earmarked for roadside land.
Seem to be encroachers of 31 feet of government reserve land. That is paragraph 19, my lord, we have stated.
That is your stand. But he is not an encroacher according to him because his patta says prima facie.
My lord.
Isn't it?
73.
His patta says 35. Your map says 66.
Lordship.
Now, what will happen in that case? Think over it.
And one line I add also, that in the map you will find that it is 192. Dag number 192 is specific, clear one, and beside alongside the dag 92, there is 162. My plot is there, so it is independent, regular.
Where?
192. There is the road they are showing. The one where the 66 feet on the right side is written. This 192 dag is a independent dag.
I'm not getting 192. When is the where is
192 is on the line.
1, 2, 3, 4, 5, 6, 7, 8, 9.
190 I have got.
192 there is a straight line. 2 lines are there. There is showing the road.
Whole is 192.
Yes, total 192. Then on the along side is it is my part, 162. Now this
Which one is your?
There is the where 66 which is written
Ah.
just below the arrow mark. This one is 162.
162, madam. Just
160
arrow mark.
160
is my
is
land.
your Doug.
And 192 is the PW road they are sitting. So it is a
So according to is this is 162 is petitioner, isn't it?
yes. And there also is
And this road 192, whole 192 according to them is a roadside land.
yes. As per this, and I also agree. Yes, this is as per the survey. It is being 192 is there.
My lord, in paragraph 19, my lord, we have stated that my lord, the petitioner who insisted on extent of 35 feet reservation, however, his whole patta land of 3 bighas, 0 katha, 15 lachas is intact. My lord, starting from distance of 66 feet, he is seen to be encroacher of 31.
They have not
between
yet.
of government reserve.
I respect. They
Paragraph
have not
19.
yet measured the thing.
So let them
So-
measure it.
Yes, let all the
Let them measure it and
Yeah.
thereafter
if they find in that case, it's very.
I think that is hard. Let them measure after you if what.
Let the report come how it
Okay.
will, because not only mine and measurements
Hard.
then the whole.
Mr.
The Mohguli will
Professor
come.
Learned Counsel for the petitioner and Mr. U. Das, MS U. Das, Learned Counsel for the
2, 3 and 4, and my friend
3
is
and
appearing.
4 and Bodoley for 1. The claim of the petitioner is that without acquiring his patta land, the respondent state has constructed a road. Already constructed?
No, they have not gone. They are just trying to construct. First, initially they.
Is proposing to construct a road over his patta land. According to the petitioner, it is specified in his patta land that there will be a 35 feet land reserved for expansion of road in front of his patta land. However, the respondent authorities is seeking to go beyond that 35 feet and rather trying to expand the road up to 66 feet, thereby encroaching upon the land of the patta land of the petitioner. On the other hand, the state respondent, relying on a map prepared in the year 1969-70, submits that there is already a land measuring 66 feet in breadth reserved for road, and the petitioner is encroacher to the aforesaid land. Aforesaid land. Full stop. In view of the aforesaid, though the affidavit has been filed, all the facts are stated by the officer to be from his own knowledge, and no record has been produced in this regard. Be that as it may, as the dispute arises, it is also a stand of the respondent authorities that even after construction, even after exclusion of 60 feet roadside land, the petitioner land measuring 3 bighas, 15 lessas shall still remain intact. Therefore, petitioner cannot have any objection for construction of road in front of his patta land. The learned counsel for the petitioner has objected to such a submission and contends that no measurement has yet been carried out by the respondent authorities, and he is agreeable to a demarcation and measurement of the land so as to ascertain the actual fact.
In that regard, I will submit a representation, page 43.
Full stop. Accordingly, he had also filed a representation before the authority. Considering the nature of the dispute, this court is also of the view that to ascertain whether the land shall be constructed over the patta land of the petitioner, an exercise to demarcate the government land earmark for the earmark reserved for road, and the petitioner parta land should be made and should be made. Accordingly, it is directed that the concerned revenue circle officer shall get the demarcation through his subordinates and to submit a report whether the proposed 60 feet roadside reserve land encroaches the land of the petitioner as described in his patta issued by the state authorities, or whether even after exclusion of the 66 feet roadside land, the petitioner's patta land remains intact. Full stop. Said report be submitted on the next date fix. List this matter after vacation. The petitioner shall cooperate with the authorities.
Pray for it. Receive revenue in the cause for reflecting the name of its.
Cause, okay, registry to reflect the name of standing council revenue in the cause list. Yes.
Bless.
Infrastructure
Has expired, so it may be closed.
expired in normal or somebody has killed him? No.
Yes, sir.
It is submitted that the petitioner has in time expired. Therefore, no there shall be no cause of action to pursue this writ petition, as the prayer made was to provide PSO to the petitioner. Accordingly, the writ petition stands closed to infrastructure. What do you say?
Three issues perhaps call for a lordship determination. Firstly,
just we want to know whether how much will go, what order will pass, that is a different issue. But we want to understand.
the issues would be whether firstly the payment which has been made by the respondents to the petitioner, whether that is an ex gratia payment or whether there is a legal entitlement. If it is an ex gratia payment, your lordship, my understanding is there is no question of interest because it's ex gratia.
It's a ex gratia.
It's ex gratia.
It's a gratuitous activity.
There is no legal obligation.
No
of them to
legal.
pay.
Yes, no clear.
So, but if it is not an ex gratia payment, then the question of interest will arise, your lordship. Then if the question of interest arises, your lordship, then the next question will be how much interest and for what period? And secondly, whether in proceedings under 226, in what circumstances such interest can be awarded. So I have prepared three judgments, your lordship, otherwise the issues are
settled,
here, perhaps more or less settled.
Now, what is the stand of the bank in the affidavit?
The bank, though the scheme itself, your lordship, it says the nomenclature is ex gratia payment on death of an employee, but mere nomenclature perhaps.
No, nomenclature not, because these banks are having, see, gratuity is paid under Payment of Gratuity Act.
Yes, your lord.
And Payment of Gratuity Act also prescribes that the individual organization can have their own payment scheme.
Yes.
Which, however, cannot be less beneficial than the that is provided under Payment of Gratuity Act. So whether it is a gratuity on an ex gratia.
Lordship, this scheme says that it was formed, your lordship, in light of the judgment in Umesh Kumar Nagpal. So it is a payment which is given in lieu of compassionate appointment. That is the purpose of the scheme. The scheme has been enclosed to the affidavit in opposition.
Okay.
It is
so if it is in lieu of compassionate appointment, it is nowhere relatable to Payment of Gratuity Act. Okay, so that part is gone. Now, suppose it is a compassionate appointment. Why compassionate appointment is required? To tide over the emergent situation. If a person is allowed to suffer
yes, your lord,
for years, the scheme itself object is defeated. Second thing is that it is for whose fault there was delay.
paragraph number 6, they have given some explanation
Mm.
for the delay.
Mm.
And I don't think an affidavit in reply has been filed in this matter. So that perhaps will fall for a lordship determination on the factual aspect. They have given some explanation that some document was there, that document had to be replaced. Some explanation is there on affidavit. But delay has occurred. If your lordship holds that the delay is unjustified and they have suffered and the rights under 21.
Suffered is a foregone conclusion.
Yes.
Because it is a compassionate kind of thing that is foregone.
Yes. Then your lordship may have a look at paragraph number 6 of the affidavit in opposition.
What is this, Mr.?
This is declaration.
What declaration?
Declare that no other claim of any amount or appointment under compensated ground will be made.
That is a condition precedent.
Yes.
That's why you have given the.
That is the declaration.
That is declaration that I will not seek any appointment or any benefit.
Or any amount.
Any amount.
Any amount. That amount is.
No, what we are proposing for not for her claiming. She has not claimed. She has not claimed interest. We are in claim.
There is a prayer.
No, that
Prayer is there.
prayer is there.
But here is no claim of interest.
No. See, Mr. Goswami, she has made a claim for interest.
In the
She
petition, yes.
made a declaration that give me this amount, I will have no other claim. But if you delay in paying this, will that declaration will give you a right to pay whenever and whatever you like? Will it give you a right that, okay, she has given a declaration, we'll pay after 10 years. Okay, forget about what is this? Will it give you a right not to pay interest? You are a state authority, a instrumentality of state. We expect something more particularly when one of the bank's employee expired. Widowed lady seeking help. There you have demolished, you have abandoned the scheme of compassionate appointment, you leave of payment. If you delay the payment, why not interest? After puja. After puja.
After puja.
After puja. These are important, according to me, these are important issues. Subject to what other things.
If the matter is part heard.
Hard in part. List this method for further hearing on. Keep the assessments if you can copy or if you can cite so that I can
Lordship,
come
keep your
prepared.
copies, your lordship.
Give him also the
Yes, sir.
citations.
Lordship, there are two judgments which your lordship will see, that is on the issue that when the lordship holds that the claim is ex gratia, then perhaps there cannot be a right to interest. But if your lordship were to hold that that's a legal entitlement and then fundamental rights have been violated, then it is in your lordship's domain to grant interest.
Whether compassionate appointment is an ex gratia.
Yes, that is an issue which will have to be determined.
Think over it.
Yes, sir.
Oblige. Think over it. We will not pass any order emotionally.
Yes, sir.
We want a legal backing and legal support. That's why I have requested you to assist.
Well, deeply.
2810.
28. 10.
Very only. No, 2810. No. Not 2810. It should be within 1 month. Immediately reopening. 21.
Item 10.
May it please your lordship.
Yes, you
Lordship.
wanted an adjournment.
Yes, lordship.
Who are these private respondents? Who is this Topnath Seal? The petitioners alleges that patta land of the petitioner have been evicted from Patta land by the circle officer with the help of police. Full stop. On the other hand, the circle officer
Private respondent has.
page
filed one
58, na? Circle.
Complaint.
Huh?
Respondent number that private respondent has filed one complaint.
Where is that complaint?
No, it is mentioned in the page 54 of it, in the.
Where is your affidavit? Page 50. Has filed an affidavit
Respondent number 4 has.
and
filed.
has taken a stand that the circle officer has evicted the petitioner in exercise of power under Rule 18 within bracket 2 of the settlement rules, and that the land is a government land. However, he declares that the statements made in the affidavit are true to his knowledge.
That is actually filed by.
This will not be done in this court. So and so, all knowledge will not. In view of the aforesaid, the circle officer shall produce the relevant record on the basis of which has a statement to be knowledge. However, the such statements made in the affidavit are relatable to different government records, and therefore the circles officer shall produce the relevant record on the basis of which the eviction was carried out before this court on the next date fixed. Release this matter on 21st of October 2023.
Obliged.
11.
Yes, somebody sought for an adjournment.
My lord, in the morning, my lord.
Yes.
Yes, my lord. Mr. Gautam Chaudhary had some difficulty in the morning.
Okay.
So perhaps that on that ground it was sought. Even otherwise, my lord, the respondents were supposed to file affidavit in opposition.
Yes, who will file affidavit here?
The Pollution Control Board, my lord.
Yes, Borua. There is an interim order also.
Petition only. Adjournment of an question.
Pratibha ko chilo. File lo, boito file.
Yes. 2019 matter. You have taken an action.
Yes.
Against them, they have come.
They have come.
They are raising some issues that this is not applicable, this is not applicable. We need an affidavit from you. Mr. Borua, learned Standing Council for Pollution Control Board, Press Foreign is granted 2 weeks time to file affidavit in opposition. Please take on.
May it please your lordship. My lord, this matter relating to the post of president of Nalbari Jilla Parishad. The term is over. 5 years time has already been over, and another writ petition, which was numbered as my lord WPC 1493/2019, my lord. It is also my lord disposed of on 12/2/2024 regarding the same issue.
What was the issue? What was the determined on that writ petition?
No, my lord, because the government is directed to, as per procedure, they will my lord reserve the post.
So we'll close it as infructuous.
Yes, yes.
Keeping the questions open.
Open.
Okay. The present writ petition is filed assailing legality and correctness of a notification bearing number PDA.474/2007/228-D dated 28/1/2019 issued by the government of Assam in Panchayat and Rural Development Department to the extent that it excludes Nalbari Jila Parishad for reservation of office of the president for women on rotation basis. Full stop. The issues involved is whether a district can be excluded for the policy of the government to reserve the president of Jila Parishad for an women on rotational basis. Full stop. Rotational basis. Mr. Goswami, learned counsel for the petitioner, however, submits that the term of the Nalbari Jila Parishad has already been over, and therefore he has instruction to withdraw this writ petition with a liberty to file a fresh writ petition to raise the similar issue if so advised. Full stop. Prayer is allowed accordingly. Writ petition stands closed on withdrawal with the liberty as prayed. Because issue is having an importance, so we are not
Yes,
close it.
Obliged, my lord.
13.
The petitioners claims to be none appears for the petitioner on call. The petitioners claims to be very poor cultivator belonging to scheduled caste community and claims that they are doing their agricultural activities in government over government caste land, and they have also been permitted by the revenue authorities to carry on their agricultural activities over such land. It is their further case that the forest department otherwise disturbing and trying to evict them, claiming the land to be forest land. Full stop. According to them, the revenue authority claims the land to be government caste land, and the forest authority claims the land to be forest land. And in the meantime, the forest authorities are trying to evict the petitioners. Full stop. None of the respondents, that is neither the revenue authorities, revenue department, nor the forest department, has filed an affidavit till date. Yes, clarifying their stand. At this stage, MS Bordole, learned standing counsel, none appears for the forest department on call. Though MS Bordole, learned standing counsel for the revenue department, press for 3 weeks further time to obtain complete her instruction and to file an affidavit. Full stop. Mr. MS S. Borua, learned counsel appearing for the deputy commissioner, also make similar prayer. Prayers are allowed. List this matter after puja vacation. Enabling the respondents to file their respective affidavits.
14.
Still pending?
Yes, Lord. There is
It is submitted that the SLPC within bracket CC number 2368/2020 23628/2016, which in essence on the same subject matter is still pending before the Honorable Apex Court. Full stop. Accordingly, this matter stands adjourned till the disposal of special leave appeal CC within bracket CC number 23628/2016.
Bye-bye.
Yes.
Well, this is regarding unauthorized construction, notice was issued on 19, but the private respondent has not filed any affidavit till date.
All are duly represented?
Yes, my lord.
Now, what is to be done today?
My lord,
We fixed it today for dismissing it for default.
oh,
This
my lord,
matter.
last day, last occasion.
Not last occasion, two occasions. So you got a lifeline on the last date.
Sorry, I'm very sorry. On, yes, on last occasion,
Last occasion, prior to that occasion. Now, what is the present position?
what happened, my lord, the private respondent, my lord, he has built up an 5-story huge building, my lord. He's just adjacent to my plot, my lord. My plot, my lord, is in existence in 1976, along with a, my lord, Assam type house, my lord. What happens, my lord, after he has constructed in 2007?
Now, who will file affidavit? Whose affidavit is required?
Silchar Municipality Board, my lord.
Where is Silchar Municipality Board? They are for private respondents.
I am for private.
They are private respondents.
They have built a building, my lord.
They have built up building, but you say illegality, if they have been permitted, they have constructed. Illegality is on the part of the Silchar authority, either granting beyond their power or not acting in case of
Exactly.
violation.
Yes.
Either of this case,
Yes.
even if we go to the brief.
Yes.
Where is Silchar?
Earlier it was Silchar Development Authority, my lord. Now it's, the power is vested with Silchar Municipal Board.
But Silchar Development Authority has granted, my lord. So,
Whosoever granted, now who will represent this authority? Respondent number?
phone number, my lord, is 4 and 5 are the Development Authority, and 3 and 4 are the Municipal Board.
Any service is complete?
Yes, service is completed now. We have taken
Any
three
name
steps.
shown?
No, no names shown, sir. In fact, we have made the earlier chairman of Silchar Development Board, my lord.
Private forget,
as a
if they
private-
are not
as a
here,
party.
no problem. But if Silchar authorities, even after receipt the notice not present,
Yes.
where is Mr. S. Datta? CC Datta, senior advocate.
Normally appearing
He
for
normally
Silchar
appears.
Municipal
Yes.
Board.
Okay. You do one thing. Inform Mr. Datta, we are fixing it, this matter of, within a day or two. Then we will request him to obtain instruction.
My lord, that will be good.
We will not say that list. Mr. Sahila, can you intimate him? Okay. Though service is complete, none appears for the Silchar Municipal Board.
Silchar Development Authority.
Silchar Development Authority and Board, both. Silchar Development Authority and Silchar Municipal Board, whose presence is very much necessary for proper determination of the issues. Full stop. It is brought to the notice of this court that Mr. S. Datta, learned senior counsel, generally appears for Silchar Municipal Authority / Silchar Municipal Board. Therefore, having no alternative, this matter stands adjourned with a direction to register direction to the registry to list the matter reflecting name of Mr. S. Datta, learned, list adjourn this matter. Accordingly, list this matter on, give a date. Any date you can, it will be short first. We will not determine anything on that date until and unless we 16th.
No, like it will be on
18th of September 2024. It is requested to Mr. G.N. Sahila, learned senior counsel, to intimate Mr. S. Datta so that he can remain present on the next date fixed to fix so as to assist this assist this court as regards the service of notice upon respondent Silchar Municipal. Interim order passed earlier shall continue till the next date of listing. What is the interim order? What is, they have completed the
Status quo.
they will be happy for the status quo. Isn't it?
Well, it was long back. Constructed.
Yeah, they will be happy. Even if there is the problem, Silchar will say there is a status quo, we are not doing anything. Matter is there.
My apologies, my lord. My lord, in item number 11, there was an interim order that may kindly be extended.
Interim order, item
11.
Yes, 16.
I'm so obliged.
Lordship, 4 years of elapsed in this matter.
Hard. Mr.
J. Singh.
J. Singh, Learned Counsel for the petition. The present application is filed seeking protection from arrest in connection with
On PS case number 190 of 2009.
in connection with Moran PS case number 190 2019 registered under section 325/153 within bracket A/427/500/506 IPC read with section 25 within bracket 1 capital A of Arms Act 1953 read with section 31 within bracket 10 Roman 10 of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Full stop. The present writ petition is filed on the backdrop that no anticipatory bail can be granted under the Scheduled Caste and Scheduled Tribes, within bracket Prevention of Atrocities bracket close Act 1989. Full stop. This court, under its order dated 15/5/2020, after considering the matter, where is the order?
15-2, my lords.
Huh?
The order is 15-2/2020.
15/2 or 15/5?
15-2.
15/2. Not 15/2. Where is that 15/2?
15-5, my lords, sorry.
15/5. No, 15/5. 15/5.
Right.
15/5. Granted protection to the petitioner to the effect that no coercive action shall be taken against the petitioner, with a condition that the petitioner shall remain present before the authorities. Have you given the statement, your statement?
Lord, he has gone to the authorities, he has recorded state.
Huh?
He has gone to the authorities and recorded the state.
Okay, it is submitted that the petitioner has appeared before the investigating authorities. It is submitted that pursuant to aforesaid order, the petitioner appeared before the authorities and recorded his statement. Full stop. Recorded his statement. Recorded his statement. Where is the affidavit? No affidavit file?
They have filed it.
Yes.
What is their stand?
Lord, denial in the FIR, that is the stand. Denial of my writ petition ever been in the stand.
Okay, full stop. So a question of maintainability of this writ petition, not maintainability of the writ petition is raised. However, considering the method that the petitioner was granted interim protection on 15/5/2025 and he has appeared before the authority and recorded his statement, keeping the legal question open, this writ petition required to be closed. Full stop. Accordingly, the present writ petition stands closed, keeping the legal questions open, legal questions raised open, and in terms of the interim order dated
15/5.
15/5/2020. However, it is provided that if the investigating authority requires the petitioner his presence for further investigation, the petitioner shall cooperate with them. That is there we have already in terms of the close in terms of the earlier order. and subject to the condition that as and when required you will appear. That's all.
Next.
May I please?
This matter, I apologize, Your Lordship, we have lost our file.
Mm.
And I have received the pairwise comments, Your Lordship. Lordship will kindly grant me 2 weeks' time. I'll be filing my affidavit for this case, Your Lordship. This case is being listed after.
What is the issue here?
This is the tribal belt and block plot of land, Your Lordship. The land falls in the tribal belt.
Okay. The learned counsel for the revenue department press for and is granted 3 weeks time to file affidavit in opposition. Interim order pass earlier shall continue till the next date of listing.
Deeply obliged. Your Lordship.
18.
Notice was issued, madam, on 1/11/2019.
So inadvertently affidavit was not filed, although it was notarized,
Okay,
but somehow it's left out, Your Lordship.
Mr. Swensu, learned standing counsel for
One and two, Your Lordship.
correspondent number 1 and 2 press for and is granted 3 weeks time to
Please
file
file it.
affidavit in opposition. List accordingly.
Obliged, Your Lordship.
Well, matter relation land compensation matter.
Hmm.
My lord, land compensation, on 19/7, my lord, this honorable court directed the standing council to obtain instruction, my lord. My lord, case of the petitioner is that, my lord, he had 2 plot of land, my lord. One was mutated in his name and another was not mutated. And
Yes, thus, you thus.
who does? 19/7/24.
Can it be taken their footnotes? Because in fact, UDAS has been instructed as I've been told. So we don't have that present instruction already
The
affidavit. has been
grievance of the
filed.
petitioner is that petitioner, the petitioner is aggrieved due to non-payment of compensation against the acquisition of land, comma, which according to the petitioner, comma, he purchased by way of 2 registered sale deeds, comma, one in the year 1989 and other in the year 2007. Mr. S. Borua, learned counsel for the state council submits that this brief is entrusted to MSU Das, learned additional senior government advocate. Therefore, matter may be adjourned in her absence and be listed after vacation. So this court has also observed that a coordinate bench under its order dated 19/7/2024 directed MSU Das to obtain certain specific instruction, full stop, and place the same, full stop. Considering the matter in entirety, list this matter after vacation. MSU Das shall obtain instruction, complete her instruction in terms of this court's earlier order dated 19/7/2024.
If
Give a date after vacation. After vacation.
20.
Obliged.
No, 20.
Yes,
may I please, Your Lordship?
respondent.
May it please your lordship, I am appearing on behalf of the SPDAS for respondent number 1 and 3. My lord, as per the last order, Government of India took time to file affidavit in opposition.
Who will pay this money? Vocational training.
But 90:10 proportionate is there, my lord, 10% from the state government and 90% from central
But they
government.
will not pay 90 and 10 directly to you. They will pay
No,
somebody.
yes, yes.
Isn't it? Who is responsible to pay you?
The Directorate of, my lord, Employment and Crafts Training actually are paying us, my lord. But that fund is, my lord, released by central government and state government.
The central government is a party
My
respondent.
lord.
Who is representing Union of India? Union of India?
There occasion, my lord, Mrs. A. Gayan was representing.
I will, if you inform A. Gayan, and kindly
Ah.
pass over the matter for time.
This matter pertains to non-payment of contractual dues, comma, which according to the petitioner is admitted amount. Such due, comma, according to the petitioner is against the vocational training imparted by the petitioner institution.
My lord.
Petitioner institution upon beneficiaries selected by the respondent number 3. Respondent number 3. What is the stand in the affidavit?
My lord, they have taken the stand, my lord, they will pay subject to release of the fund by the central government.
And what is the stand of the central government?
Central government has not held. my
Where
lord,
is the affidavit? Affidavit by
My lord,
the
question number 3, my lord.
the respondent number 3 has filed an affidavit.
In para 11, it is stated that, my lord, they have already submitted proposal, my lord.
Para
11, my lord.
the respondent number 3 has filed an affidavit and has taken a stand that that submits that the amount due is 45,18,918, isn't it? According to them? According to them, 45,18,918 has admitted the due to be rupees 45,18,918. However, it is their stand that the same shall be paid.
No, my lord, that is not the statement.
No,
my
no, no,
lord.
no.
Paragraph 10, my lord.
Hmm.
Where
What
they
is it? What is
They have stated, my lord, that already paid rupees 45,18,980.
and what is the due?
My lord, now outstanding due is, my lord, after deduction of this amount, my lord.
Where is
we
the
have
due?
46,26,960.
Outstanding due is it is admitted 46,26,960. It is their further stand that the same amount shall be paid to the petitioner. Petitioner on receipt of a fund from the government of India, isn't it?
As well as government of Assam.
As well as from government of Assam, inasmuch as according to them, such schemes of vocational training are being financed by the Union of India and state government. Full stop. In view of the aforesaid, an affidavit shall be required to be filed by the state respondent. Which is the department state? This is only a
Secretary Labor. and
Skill,
Employment Department.
skill employment and
affidavit is
entrepreneurship
required to be
department.
filed by the respondent number.
My lord, one,
Respondent number?
we have filed, my lord, but state government.
Respondent number 1 and respondent number 4. Full stop. MS S. Borua, Learned Counsel for the respondent number 3.
On behalf of A. Gayan Lordship.
No, praise for and is granted. Who is representing Commissioner Secretary, Skill Development?
For respondent number 1,
1 and 2.
No, she is for, you are for.
1 and 3, respond number 1 and 3.
So you have filed a affidavit.
We have filed a affidavit.
Okay, not necessary. No. Therefore, an affidavit is required to be filed by the respondent number 4. Full stop. A. Gayan, who is representing?
A. Gayan is leading
Okay.
this.
Is she here in the
Yes.
today in the court?
No, today he says not.
Okay, it is submitted that Mr. MS A. Gayan, Learned CGC, is representing the Union of India and she is out of station today.
On behalf of.
Accordingly, MS S. Borua, on appearing on behalf of MS Gayan, prays for an adjournment. First of prayer is allowed. List this matter on, give a date after vacation. What is this business? If you don't have money, don't train them. You will take clap from everybody that vocational trainings have been given. And the institution who is imparting the vocational training will be closed tomorrow for want of money. This is a fraud on people. This is nothing but fraud. 23rd of October, 2024. And shall clarify, the Union of India shall clarify their stance as regards release of their liability to release such fund and release such fund.
Their occasion I submit.
Yes,
It is covered under.
said covered, yes.
No, Your Lordship, the notification not cover, Your Lordship, because the construction of the line was not much before 2015. If Your Lordship goes.
Now,
to
what
the-
was that provision then?
Your Lordship, if Your Lordship goes through the notification.
No, if you say that you want to have some deliberation on this, we'll fix this matter.
And there is a completion date.
One thing I'm pointing out, my lord, this petition itself is not maintainable, my lord.
We'll record your name, please.
And even-
It
And
will not hear two lawyers.
This is not maintainable because as per 16(4), Your Lordship, he has to file a civil revision petition challenging the judgment passed by the London District Judge.
Already district judge and past and
He has to challenge the judgment by filing a CRP, civil revision
no,
petition.
that will be a different issue. So
Yes, Your
according to you, the scheme is not applicable in
Not
this
applicable,
regard.
because line was.
And
much
he,
before-
and already it is determined by the district judge under section 11 or something.
16(3), Your Lordship.
16(3).
Take effect, correct.
So that is, if he is aggrieved by that, he is have other remedy, not
Yes, Your
the,
Lordship.
this
Not-
is your
not
case.
writ petition. As- I think
Subsequently, my lord, there is a notification regarding guidelines, my lord.
No,
My lord,
is that notification says that you are entitled for the benefit from our anterior date.
No.
But at the time of my lord issuing that notification is still continuing, my lord.
That
It's
is a,
not
that is a
completed, my lord.
debate, legal debate. That
If Your
is a
Lordship-
legal
if Your
debate.
Lordship goes to the second page of the notification, which is provided by my colleague on the last date, Your Lord. Fourth
Yes.
paragraph, second page, fourth paragraph, Your Lordship. The above guidelines. Your Lordship has-
Second page,
The fourth paragraph, the above guidelines. If I'm allowed to read the Lordship. The above guidelines shall be effective from the date of issuance of the above mentioned Government of India guidelines and shall be applicable for only those new transmission lines projects which constructed have started after this date, that is 15/10/15. The particular line was constructed much before 2015, compensation was paid. He has received the without any protest and also approached the London District Judge against the assessment of the compensation, Lordship.
If they are under protest, my lord.
what is challenge in this writ petition?
Petition, my lord, one of the challenge, my lord, the district judge order, my lord.
No, so we'll admit it. We'll hear it some other day.
My lord.
Lordship, maintainably may be kept open if Your Lordship is convinced, because he has to file a civil revision petition.
No,
As
no,
per
he,
sections-
There is no provision in the Telegraph Act or
16.5 says,
Electricity
Your
Act, my
Lordship.
lord.
And even
It is
AI
provision.
1967 judgment is there, Your Lordship.
That is, that will,
CRPS,
still you have time to withdraw it and file your civil revision petition. Within any
2020
time
matter.
prescribed?
Not, Your Lordship.
No,
But he has to
2020.
approach the immediately after the assessment, Your Lordship.
That's fine, but that can very well be, where is your prayer?
My lord, can they say, my lord,
Prayer
sir,
page 14, Your Lordship.
So you want a challenge impugn judgment dated so and so.
and mandamus also.
Shall
my
not be
lord.
issued direct the respondents forthwith cancel, recall and forbear, giving effect to the, no. Basically challenge is the judgment.
Yes, Your Lordship.
Where is that judgment?
Page 65.
Page 65.
No, you are relying on section, Telegraph Act.
16.3.
What it reads,
No,
reads.
AR 1960.
Telegraph Act, Your Lordship. He has to approach the learned district judge if he has any grievance against the compensation.
No, what is that provision says the remedy against the authority decision of the district judge?
AI 1967, page 1.
What
Page
it reads,
paragraph
what
63, Your
it
Lordship.
reads?
If you am allowed to read, Your Lordship.
Yes. Mr. Patgiri, why I am saying is, instead of dealing with this repetition for years, one day, fine day, it will be dismissed. Isn't it? So better make a prayer that we withdraw and file a civil revision petition, because your whole prayer is for challenging the order passed, statutorily passed. So that is the best way.
1967, page 1.
I see, my lord, that
AI
judgment about
1967.
judgment.
Okay, you have your satisfaction.
My lord.
Nothing will happen. I also know that I forgot that.
AI 1967.
Just read this paragraph.
Yes, sir. Sure.
Heard Mr. K.R. Patgiri, learned counsel for the petitioner. Also heard Mr. N.C. Das, who is virtually present, and assisted by Mr. A. Das, who is present in the court for respondent number 2 and 5. The present writ petition is filed assailing an order and judgment and order dated. Just read the
Yes, sir.
judgment in the meantime. No, ask him to read. Judgment dated 5/2/2020 passed by the learned additional district judge, Borpeta, whereby Miss Reference Case number 01/2016 filed under section 16 within bracket 3 of the Indian Telegraph Act 1885 was dismissed. Full stop. Mr. Yes, what it says?
After, my lord, 2 weeks, my lord. I
What, Mr.
prepare, my
Patgiri,
lord.
we do not understand. It will take 5 minutes. What is the meaning of adjournment? We'll give a much more better time to other cases. Apparently, I'm also convinced. For your sake, read this judgment.
Paragraph 63.
Paragraph 63. Page
It is
18.
in, yeah?
Donation part, my lord, dated.
We are providing that. We are providing that.
Then, my lord.
Give the judgment. Full stop. At this stage, Mr. A. Das, learned counsel for the respondent Swenso, referring to the judgment of the Honorable Apex Court in Naresh Sridhar Mirjakar versus
State of Maharashtra, madam.
State of Maharashtra, reported in AIR 1967 Supreme Court, AIR 1960 Volume 1, argues that page
1, Your Lordship.
See, page 60
page 63. Paragraph
page
63.
1, paragraph
63, Your Lordship. 114, I forgot.
page 11,
Must be 1.
paragraph 65.
Page
is that-
18. Page 18.
Paragraph 63.
63. Is a constitution bench judgment.
Yes, Your Lord. Third paragraph must be the ultimatum.
Refers that 63. that the writ of certiorari shall not lie to quash the judgment of the which certiorari shall not be available.
Against the judgment of the inferior civil courts, third paragraph, must be the third paragraph, see paragraph 63. The ultimatum starts from the ultimatum.
This relates to which judgment, provision of what? This is not relatable to this act.
Not lots, but
I thought this principle is settled.
yes, your lordship, that's
This is not 67 is required. Radheshyam is recent judgment.
that is there, your lordship.
This is not required. I thought this is on this point. No, we are not going to that.
As your lordship, please.
See, this is not a civil court.
Yes, that's correct.
This is not a civil court, and a person cannot be remediless. In Radheshyam, falling from this constitution
Yes,
bench
Your
judgment, it clearly says that against the civil courts.
Under special act, my lord.
It is not, it is kind of a tribunal.
Correct, your lord.
It is not a civil court, it is a tribunal. Against tribunals order, still writ petition shall lie.
Even
Maybe labor court tribunal, maybe industrial tribunal.
even the present respondents, your lordship,
Not
they had filed the writ petition.
not necessary.
And
Admit this appeal, admit this writ petition, call for the records are there.
no, your lordship.
Call for the records from the additional call for the record of misreference case number 0. There is no provision of appeal in this under 16.
No, my lord, no. Because this court had held that writ petition does not lie against the judgment of the London district judge. The present respondents had filed writ petition challenging some order passed by the London district judge, and this court lord had held.
Where is that?
I have the writ petition number, your lordship. We have to withdraw and you have to file the civil revision petition.
No, if there is some ratio that so far relating to Telegraph Act specifically, then of course we will be bound by that determination.
Challenge the quantum of the compensation passed by the London district judge. Then we had to withdraw the writ petition and
This petition.
no, your lordship, we, the respondents, had
okay.
filed the writ petition, challenging the judgment passed by the London district judge, challenging the quantum of compensation. Then we had to withdraw and you had to file the civil revision petition.
Any determination ratio?
No, your lord, against the judgment or by in this judgment, your lordship. This court had held that AR 1967, we have to file a TRC.
Sir, does please try to understand.
Yes, your lordship.
Is there any judgment on the Telegraph Act by any court which says that remedy against a judgment or order passed under section 16 within bracket 3 of the Act is not a writ petition, rather a revision? Any law?
You have to check, your lordship.
So that is why I am saying.
Yes, your lord, that's correct, your lord.
Okay, list this, comma, not admit. See, what proposition of law you are saying
Yes, your lord.
is applicable in case of civil court.
Correct, your lord.
It's specific in the Radheshyam's case that no writ petition will lie against any order of a civil court.
Your lord.
Okay?
Yes, your lord.
Now, here is a case, it is not a civil court as such, per se, exercising power under CPC. It is a tribunal constituted under a special act. It's a Board of Revenue. Board of Revenue also deals with civil jurisdiction, but it is a tribunal, kind of a adjudicatory authority, which is a creature of a statute, special says, and still we are entertaining writ petition. A person cannot be made remediless. And when there is no remedy, it is the writ petition.
Your lordship, 16.5 says no one can file even the challenging judgment of the London district judge, 16.5 of the Telegraph Act. If your lordship produces 16.5.
Which paragraph says?
Telegraph Act 16.5, your lordship. Telegraph Act, your lordship. Not this judgment, your lordship.
What it says, read it.
Yes, your lordship. Sorry, Your Lordship, taking
Telegraph এখন আছে।
every determination of a dispute by district judge.
Hmm.
It's every final.
That is what I am saying.
Yes, Your Lordship.
Wherever any statute says it is final, it is the extraordinary jurisdiction which is the remedy.
That is there, Your Lordship. That is
If
there.
that is there, that is what I am
Under
saying.
256. Correct, Your Lordship.
Nobody can be made remediless.
Remediless.
Writ court is there. It is a basic structure.
Yes, Your Lord.
Nobody can say that writ petition is barred because no final relief is granted.
Yes.
It is our discretion
Yes, that's
whether we'll entertain or not entertain.
correct, Your Lordship.
List this matter for admission. On, give a date. After puja. 23rd, full stop. In the meantime, registry to call for the record of MC within bracket REF case number 01 of 2016 from the office of the learned additional district judge, Borpeta. Then we'll see, we'll admit or we'll decide on that date.
Your Lordship.
Maybe.
Yes.
Petitioner is the contractor was awarded certain works by the state, under the state disaster response fund. my lord. Now he is not paid the bill of.
What is this? What is the stand in the affidavit?
Then, my lord, she says, my lord, it has been forwarded to the.
We'll go to stand means, do they admit?
Yes.
Where is that?
Yes.
We'll go to later on where file
Fine.
has moved, but first we need the admission.
My lord,
Which affidavit, which paragraph?
affidavit. Filed
That
by
is
the
my
deputy
table.
commissioner, respondent 6.
Paragraph?
Yes, ma'am, paragraph 5.
Additional deputy, paragraph?
Paragraph 5. And 6.
Okay. What is the stand, other stand?
That the water resource department says that since the work was under the subcontract, it requires some approval from the disaster management. Since the work was under some subcontract, my lord.
Subcontract by whom?
Subcontract, my lord, it is not a part of the main contract. It was additionally done,
It was an additional work for which the departmental approval was nothing.
my lord.
Therefore, the entire thing has to be placed before
The state executive committee
State Executive Committee.
of the revenue.
Now, the latest instruction I have, which says that the department has sent the proposal to this one, my lord, Assam Disaster Management, State Disaster Management, to be placed before SEC, State Executive Committee, and a report from the this one, Water
Deputy
Resource
Commissioner.
Department has been called for. This is the-
But mind it.
Mind.
The interest is clicking.
No, Lordship will kindly appreciate, my lord. The
Will
main
not
work he has done.
You listen to us. You have an urgency. We can understand. So you'll ask a contractor, please execute, do it. This is disaster. Okay, we can go up to that. Moment it is executed, where is your concern and disaster? How many, when it was executed, tell us.
Work was under in the year 2018.
17-18.
Then
It was done at the district level, man.
we understand,
There-
but it was done.
Yes,
It was relatable to disaster management.
Right.
It was done.
done.
So therefore,
That it was done.
that it was done,
It was
and
has to be-
then it is your responsibility to carry forward whatever approval, ex post facto approval is required. You will have to do it. Once you have admitted, it is your bounden duty. And if there is a delay for 3 to 4 years, 5 years, that interest is to be paid, and will fix this time the interest upon the person who is responsible for this delay. That's all. Otherwise, again, I am saying this is a fraud upon the contractor. Everywhere we have seen, you will, that, okay, you do it, we are giving approval, work is executed, then what not, what approval, this, that. So do whatever, will record all these things.
Dr. May kindly have the instruction.
Yes,
latest.
give us the instruction. The present writ petition is filed claiming an amount of rupees 25,75,803 for execution of contracts works undertaken under SDRF capital scheme of Dhemaji Water Resource Division. Full stop. That the petitioner has executed the work and successfully completed the same has been admitted by the Deputy Commissioner Dhemaji in its affidavit, inasmuch as said Deputy Commissioner was authorized to monitor the execution of the work strictly as per plan and estimate. It is also not disputed, no respondents has disputed that the petitioner has executed and as regards his executed the work and as regards his claim. However,
I have given this.
Huh?
Our affidavit in paragraph 8, we have stated that is the extra work done by them as per reported by
full stop. However, it is the stand of the, you are for?
Revenue Department. my lord.
It is the stand of the Revenue Department that as the work was an extra work, ex post facto approval will be required for payment of such money, and the ex post facto approval needs approval at different administrative levels, including what is that committee?
State Executive Committee.
State Executive Committee of under Disaster Management Act. Be that as it may, when admittedly an work has been executed which is relatable to disaster management and amount is admitted, it is, in the considered opinion of this court, is the responsibility of the authorities to pay the amount at the earliest, in advance as delayed payment shall have civil consequences upon the contractor. At this stage, the learned counsel representing the respondents submits that the entire process can be completed within a period of
It's difficult because I didn't get the instruction that's about the time frame. my lord.
within a period of, tell us that instruction you must have.
Dr. May kindly give me 15
I am
minutes.
giving you 15 minutes time within a period of so and so, so and so. Considering such submission, this matter stands adjourned and be listed on so and so, so and so, by which date the state respondents shall complete their furnish instruction as regards status of payment of admitted bill to the petitioner. Yes, next case.
Wait, Your Lordship.
Mm.
Lordship, I have prayed for adjournment for this item also.
Okay.
May I please, Lordship?
Mm.
On last occasion, Lordship directed to file affidavit, but our instruction has already placed before the court on 12/2/24, and it is marked as debtor ex Lordship. Yeah.
The petitioner claims the petitioner is aggrieved by a notice dated 9/1/2022 issued by the circle officer Gosaigaon Revenue Circle, whereby the petitioner has been asked to allegedly, whereby allegedly the petitioner has been asked to vacate from the land and remove the growing crops. Full stop. On the other hand, it is the stand of the respondent and then the learned counsel on instruction has submitted that the respondents had no intention to evict the petitioners from their patta land. However, the different lands were allotted to different institutions, including to Dr. B.R. Ambedkar Bhavan, Habur Bill, Gosaigaon, over government plot of land. Government land were allotted, or not over, government land were allotted. Government allotted. Accordingly, to hand over the possession of the government land to the allottee, a notice was issued to the petitioner for demarcation of the land. However, for the obstruction created by the petitioner, the demarcation could not be executed. In the aforesaid backdrop, this court, under its order dated 12/2/2024, made clear that the pendency of the writ petition shall not preclude the respondent authorities to take steps as otherwise permissible under law. Full stop. The learned counsel for the petitioner seeks an adjournment. Prayer stands allowed. However, it is reiterated that the respondent shall be at liberty to proceed with the demarcation as per law. However, subject to the condition that they shall not evict the petitioner from their patta land. In fact, we can dispose of with this order.
On next date, Lordship.
That is what you want. Yes, next case.
Organized.
25. Yeah, please, Your Lordship.
Hmm.
My lord, APDCL already filed their affidavit and admitting that the husband of the petitioner died due to electric shock, my lord. Kindly.
No, that there is no dispute as regards that, but anyway, as per report is not that clear. The report is not that clear.
Lord, we also have not received the affidavit.
Who are you?
My Lord, I'm on behalf of my senior for APDCL, Lordship.
Who is your senior?
Mr. J.K. Goswami.
J.K. Goswami. You have not received the affidavit.
My
You were
lord.
okay.
Yes,
Yes, 61.
You have hit the accident. You have hit the thing, but there is a
Actually, he was going there and the electricity was generated. Due to some work of Geo Tower, the conduct was
sir.
live.
otherwise you can dispose it off.
They
You prefer an appeal against this.
They admitting that leakage was there.
My lord, I have an instruction. That instruction may be perused, my lord.
What is your
From
instruction?
the department, my lord.
What is tell us. We will not peruse. We will listen only. If you can read, you read it. Or if you want to read.
As per the field inquiry, it is found that there was no any electrical accident occurred on the aforementioned
Oh,
date.
that is your opinion. Of authority, we'll go by the inquiry report committed by 161. You go to the appellate authority.
My lord.
Under 162, is that it, Mr. Bhatta?
Lordship.
162. What you say? We'll dispose it of.
Lordship, let the matter may be taken after 2 weeks, Lordship, we can, so that we can verify the.
Okay, on the prayer of the learned standing council for APDCL, matter stands adjourned and be listed on Give a
30,
date
my lord.
before vacation. This matter should not wait.
On 30, my lord. There is similar matter also fixed on 30.
30? Okay, 30.
Most obliged.
30.
But here, we inadvertently, we could not furnish extra copies to the learned counsel for GMDI.
Why inadvertently? There is an interim order in your favor.
Today, yes, I have recorded.
Okay. It is submitted that the extra copies of the writ petition has been served upon the standing council of GMDA today only by the petitioner. In view of that, matter stands adjourned. And we listed after vacation or any urgency. After vacation. If they are settlement holder, you have taken a position in other cases that their lands will be acquired.
Yes.
That's all. You take that stand. Let them go out
Let it be after vacation.
after vacation. Interim order pass earlier shall continue till. You are already out or you are still there?
But there,
Those institutions are there, those who have been settled.
yes, we were also granted settlement in a way.
No, there are some organizations in whose favor settlements were granted. And those organizations, government took a stand that will acquire this land.
It petition was filed. It petition was dismissed. Appeal was filed. Appeal was dismissed. There are
So
some-
that
it is-
acquisition, that is
Yes,
fine. If
that-
they are agreeable to that, that matter can be disposed of in terms of the division bench order. Isn't it?
Okay.
Because we cannot, whether you agree or not, this is the position as on date.
We have not been informed whether they will acquire or not.
They will acquire, they have taken a policy. Yes.
Much obliged.
May I please, your lordship? Lordship, today we have filed additional affidavit in opposition in compliance of the order of this honorable court, your lordship. Lordship, this may not be in the record.
Okay, it is submitted that by Mr. Standing Council,
Water research,
Water Resource Department, that an additional affidavit
affidavit in opposition.
opposition has been filed by the department. Same is not on record. List this matter on. Give a date. After puja?
Can it be before puja?
What is the urgency?
7 days has been gone.
Huh?
Lordship.
What is the urgency? Tell us. Before puja, we'll do urgent matters. What is the urgency?
Not so.
Not so, then it will 23rd.
28.
This is against an order passed by the CALA, which I have been directed to refund the amount which I have been paid.
Who are you?
Is the
I'm
private
the respondent number 5.
How can refund be directed?
No, I'm respondent number 5. I'm the owner of the, I'm at the,
complainant.
he's a Muhammad Temple Trust, my lord.
Who is he?
He is the one of the Savati, my lord. He has no right to name his.
Yet we understand. He was a
I'm the,
He was
I'm
a
the
Savati,
patta
my
holder.
lord.
I have the Jamabandi in my name.
So
Everything
as a
is in my-
patta holder, he has been granted. You have a claim that it should be granted to the Mahamaya temple.
Lordship,
Where is the provision reference? There is no reference. This is arbitration. Or what?
There should be arbitration, and in fact, section 3H.
Functions officio.
my lord,
When award is passed, money is transferred. He
my lord, the entire aspect is that the land belongs to Devalaya. And how they got the name
No,
mutated.
okay, understand. This is your case. His
Yes.
case is that I am patta holder.
But
We
how-
cannot decide.
Yes, my lord. That
And
is-
nor prima facie view subject to what you say, nor the authority, he has become no role after award is passed, money is given.
my lord,
Supreme Court judgment is
it-
clear.
that is there, my lord.
If that
we are-
is there,
My
we
lord,
cannot go
we have
there.
made our statement here,
Hmm.
and already the objection is given to the circle officer
Hmm.
for how they got their name mutated.
Hmm.
Because it is a trust which is given by the promoters' families, my lord, and is clearly stated in the Jamabandi that it cannot be transferred to
Oh,
anybody.
that we understand.
Yes, that is the subjudice with the circle officer.
So we cannot, if that is
I'm-
decided, then you file a suit for
This is
recovery
what-
of this amount.
That is what I'm
Can
saying.
we decide here?
Yes, yes.
We'll close it.
It is up to your lordship. I have nothing to say.
What up to your
But
lordship?
I have made my
Lordship will
statement.
decide what the law permits.
Yes,
My
ma'am.
lord,
As your lordship says so is correct, ma'am. I have stated my
Section
defense.
3H of the National Highway Authorities Act.
3H.
National Highway Authorities Act.
Any urgency?
No,
We have,
no,
I have the money with me and the interim
he is
I am
enjoying the
protected.
money.
Okay, this will take after vacation. All this. Ultimately, I'll have to write a judgment. Why no authority? What section?
Interim order shall come.
Okay, as agreed to by the learned council for the parties, list this matter after vacation and on 24th of October 2024, interim order pass earlier shall continue until further orders.
Obliged.
In this case, my affidavit has been sent for signing law.
Okay. Contractors bill.
Next one, no contractor bill, my
Company,
contract has been
company.
terminated, my lord. During my period, my lord.
Difficult.
During my period, no, I'll ultimately I have to pay for my lord, that security deposit, my lord, has to be returned. Otherwise, it will be blacklisted, my lord. Believe.
That is the
Only.
urgency.
Okay, Mr. Nayak, learned standing council for the
BTC.
PWD submits
BTC.
that, this is PWD,
BTC.
BTC, submits that, an affidavit is being filed within a period of 10 days from today.
Yeah.
Full stop. Accordingly, matter stands adjourned and be listed after vacation.
But in this case, we have received the instructions login. Sometime may be allowed to file executive law.
What is the issue here?
Lands of several tea gardens were acquired, my lord. Not under the act, they have a policy called the direct purchase. Now, everything was settled, my lord. The prices were fixed, everything. When it came to disbursement, my lord, at page 192, your lordship will find, they said that now we have done a reassessment of the tea land.
Wait for a week. We are delivering a judgment on this. That will decide your fate, whether they are having power or not.
That we did not. Because that notification is contrary to the axioms like on the page.
Let us not go to that. Since that is not under challenge, see, in fact, subsection 46, 4 or 6.
Yes.
And explain this procedure can be adopted only by special person. Is that it?
Yes.
And special person's definitions, state, authority, state, and their instrumentalities are excluded. Number 2, an exemption is given under subsection 4, laying down a procedure that under these circumstances only you can go for direct purchase, otherwise not. And if you go to the scheme, but we are that will handle when this matter issue is raised.
In this case, issue is very minimal, lordship. They have been paid less than what was agreed.
That is
the issue.
That is we'll fix this matter next week. It's a legal issue. What affidavit is required? The admitted position. We'll fix this matter on 19th. List this matter on 19th.
Obliged.
We will not go to the validity of this. But if you go in depth,
We consciously did not challenge, my lord, because otherwise de novo it happens, they are hardly material to assess, determine.
nothing is there. Nothing is there. Hope they will modify this. Otherwise, if somebody challenges, it will be difficult for them. If at least if they incorporate the procedure prescribed under subsection 4 of section 46, no, nothing is there in this notification.
And in one place they've said it is under 40. So 40 again becomes special urgency.
Even they say 46.
Yes, so they
46 also.
They says 46.
This is 46 because they say there is an urgency and this is World Bank funded project. Okay, the government is within their right because some leeway is given in subsection 4 of section 46 even to government. So they are exclusively barred to go for direct settlement under the explanation clause. But if they have taken, okay, they fine, they may have urgency, we are not here to say. But they will have to follow that provisions. And they say that we have done it in considering section 46 of the Act, 46(1) of the Act. And 46(1) itself says who can and who cannot. It will be difficult if it is challenge. This is prima facie view. Very difficult.
He
Yes.
consciously did.
My lord, that particular case, my lord, item 23. The department is praying for 8 weeks time.
8 weeks. Okay. We are giving you 10 weeks time. Wait for some time. 10 weeks time. And then after 10 weeks, give a date. Okay. That matter. Item number
23.
After 10 weeks, give a date.
31.
May I please, your lordship? On last occasion, Honorable Court directed the respondent authorities to produce the status report of Belshore PS case number 202 of the 2009.
Yes, Goswami.
Yes, my lord, status of the investigation was directed to be obtained. I obtained, my lord.
What is that?
Status to the first, along with the CD, my lord. Yeah, liquidation first. Status. First status. Then I will place the.
They've done the investigation.
Petitioner was compelled to approach before this honorable court.
Okay, fine, they have done it. The way they have given, they have done, they have arrested one person. They interrogated, they have even found some creepers in the neck. It was sent to forensic examination.
All these things I have mentioned in my petition, and one person was arrested, but he was enlarged on go on bail for not filing of CD by the concerned IO. The investigation was done in casual manner. That's why he was compelled to approach before the.
No, that in fact, from the report, we have seen that. What more you want?
No,
We'll close it.
Yes, my lord. But
If they file a final form, you file objection. If they file charge sheet, we are not commenting on whether final form or what.
yes,
This
may,
court
may I please, CD also there?
not necessary. Will not comment anything because there may be final form. He will have a right. Let us not comment
Yes,
anything.
yes. After
So
final,
that
final report.
he will have a notice. He can object.
Yes,
There
yes,
may be
yes.
reinvestigation. We are not commenting anything.
Kindly peruse page number 36, my lord. There was an order from the concerned jurisdictional magistrate to the SP to file the FF. So for not filing FF, the petitioner preferred to approach before this honorable.
No, that we
court.
understand,
Yes.
that we understand. Alleging,
He died in a different police station, my lord, and the missing FIR was filed.
laws is well different than body was found
Yes,
somewhere.
in fact, my lord, as per the CD, a higher police official monitored the investigation, my lord. That is there, my lord. No, I have also seen, my lord.
The case of the petitioner is that the brother of the petitioner was killed, and in that regard, an FIR was lodged being Belser PS case number 202/2023, which was registered under section 364/120 within bracket B/302/IPC. Alleging that investigation was not proceeded in the manner in which it should have been done. The petitioner had earlier approached the concerned judicial magistrate, jurisdictional judicial magistrate under section 156(3) of the Code of Criminal Procedure 1973. Being dissatisfied with the conduct of the investigating authority in not following the orders of the judicial magistrate, the present petition was filed. Full stop. This court earlier directed to submit the status report and also to apprise this court as how long would be required for completion of the investigations. Mr. Goswami, learned additional advocate general, has produced the case diary as well as a status report. Without commenting into the merit of investigation and the result thereof, which might have a bearing on the subsequent proceeding, this court is of the opinion that the investigation has been done in a manner it is required to be done. It is required to be done, and therefore this writ petition can be closed, in as much as it is the status as much as the status report reflects that the investigation is almost at the final stage, FSL report has also been obtained, and the witnesses a statement of witnesses has been recorded, and one of the accused person was arrested, and the and call record of the one of the accused has also been traced. Accordingly, in the considered opinion of this court, there should not be any grievance of the petitioner as regards the investigation, subject to, however, of the final report that may be submitted by the investigating officer.
Within a time frame.
Accordingly, the present writ petition stand closed. Investigation is difficult to direct a time frame. Close. Full stop. Petitioner shall be. It is needless to. The status report is kept on record and marked in X. The case diary is returned back to Mr. Goswami. Full stop. While parting with the record, it is needless to say that the petitioner shall be at liberty to raise his grievance as per law against the final form submitted by the petitioner, by the investigating officer.
At appropriate time.
At appropriate time. You have got the.
I've got the copy and somehow I managed to
prepare my own argument, Lordship.
Okay.
In hurried, I have prepared, Lordship. Only on the point which he has taken the.
Have you
stand.
given a copy to
Yes,
them?
I have given him. Only on that point, 4-0. He was very concise.
Mm. Admitted writing is from which document?
From which?
Admitted writing, who admitted and what is the document that is admitted to be the signature of this person?
Lordship, it is there in the opinion section.
Opinion.
No, no, opinion, there is generally subject to correction.
Okay.
A specimen signature is given
Okay.
and an admitted signature is given. Or, and the LS signature is given.
Question. That is
Question signature. This is the signature LS to be fraud
okay.
and LS to be signature of, see, this is the signature of you. So there should be either an admitted signature that this is my admitted signature. So comparison will be with the admitted signature and the question signature. Now, how do you get the admitted signature?
The applications form.
Huh?
Application form where they put their signatures.
So first it is to be an application form in which, therefore I am asking what were the admitted signature in this case?
Admitted signatures are appearing in the application forms. It has been exhibited by the handwriting experts.
So who has admitted this signature to be of those person?
Who has admitted?
Or whether, how can you say that this is an admitted signature? Tomorrow somebody may say this is the his signature.
Because
What do you mean by admitted signature
because they are
under Evidence Act?
because the fact that the amount has been put in the account, that is an admitted fact. Those account has been maintained by this accused person, that is also admitted fact. So those account, while opening the account, they put their signatures. Therefore, cannot be denied.
So
They
that
cannot-
documents is brought in.
Yes.
How that document belongs to that bank is to be proved by somebody that yes, this is the signature given in my bank. I'm the bank officer. Yes, this is my bank's document. This was applied by him. This is his signature.
PW6.
Who is he?
PW6 is a bank employee of that bank.
Who? What you are? He came with the record.
He exhibited all those documents.
Exhibited.
Application form, account opening form, where the signatures were appearing of this accused person.
These were the admitted signature.
Admitted signature.
Now, according to you, signature was compared with this admitted document. This application.
document.
Which are these exhibits?
Exhibit profit.
From page number 573 onwards, Your Lordship.
Page number
573, Your Lordship. Of volume 2, part 2, Your Lordship.
Volume 2.
Volume 2, part 2.
Part 2. This is?
These are the admitted signatures. These are the signatures which they had sent. They are marked as A1, A2, A3. These are the documents sent to the handwriting expert for as marked as A1, A2 as admitted
This is
signature.
admitted signature. These were seized by the IO from
the bank.
From the bank. Now, these documents were proved to be seized from so and so. That is proved by whom? The IO. IO. And what is the evidence of the person from whom it is seized?
Simply said that it was seized.
Same person or any other person? Okay.
Page 181. Examination of PW 40, the admitted writing.
Page 181.
Yes.
PW?
PW 40.
40.
The admitted signatures were exhibited.
Okay. Yes. Now, what is to be done? Oral argument?
Conviction appeal, Lordship, my argument would be.
Why smiling? This is your argument?
Yes, in short, Lordship, only on the point of 468, 467.
Mr.
Lord,
Pathak,
because the
what,
argument is that-
how do you propose to proceed in? See, more or less, we understand your argument.
Yes, Your Lordship.
Okay. You have already recorded your argument. We'll record his argument also on the basis of this document, or we can ask him to give a soft copy to. Soft copy to. So we'll modify how we dictate,
Yes,
we'll
yes,
dictate
yes.
it, your argument.
Yes.
This will be ready by the next date. If we want something to be
Verified.
clarified or query, we are not finalizing it today. And we cannot take it beyond vacation because part heard matter cannot be more than 1 month. And we have substantially heard this matter, evidence are recorded. So we'll complete this, but it will not be possible before vacation.
Lordship.
So we'll fix a date before vacation. Will not deliberate anything on that day. However, during vacation, I'll apply my mind. I'll go through all the evidences. We have already typed your written argument. Purvakasta has given a written argument. And I'll read the judgment, your evidence. If anything comes into my mind, I will note it down and I'll ask you to deliberate orally on that day. So that if anything remains, it get clarifies. Then we'll make it a CAV and deliver a judgment. I think that will, because it's a huge evidence and
I had 3 quick points in response
Yes.
to what my learned friend has
yes.
asked. I've gone through the written arguments.
Moment we read, my lord, next one we forget.
That's why we are slowly doing it. Yes. Yes, what
In
you said,
essence,
Mr. Pathak.
What my learned friend has argued today is
Ah.
in the written arguments is that the investigating officer who was examined, he has stated in his evidence that yes, specimen signatures were collected, and since he has those documents were exhibited and he has admitted that those are exhibited documents, so on that basis, Your Lordship, the witnesses need not be examined, and though there is no infirmity in the specimen collection process. In a sense, that is what
That is specifically said.
Yes.
So he is a competent witness.
Yes.
I have noted it down.
So
Yes.
I have the Lordship, the testimony of the IO, it begins at page number 192 of
That is
volume
very
1.
important. I hear IO is very important.
Yes, Your Lordship.
IO, which page?
192, Your Lordship, volume 1.
192,
Volume 1.
volume 1.
Is PW 45. What he has stated, Your Lordship, firstly, I'll not read the entire thing. He has stated curiously in cross that I have not, I'll just read it out, Your Lordship. I have not cited the persons witnessing specimen handwritings and signatures made with witnesses of this case. It is not a fact that I have not taken the specimen signatures and handwritings in presence of witnesses, and so I have not cited them as witnesses of this case. So he has agreed that he has not made all of them witnesses, but 2 of them were witnesses out of 4 people who were witnesses in the entire.
Whose presence the signatures were taken?
So there were 4 persons.
Hmm.
Their names are, Your Lordship, SB Das, SS Bhattacharjee, PK Thakuria, and G Sharma. SB Das and SS Bhattacharjee were not examined. That is correct. But PK Thakuria was PW 6 and G Sharma, Golab Sharma was PW 29. They were examined. And they did not say anything about the specimen collection process in their testimonies, either in chief or in cross. Secondly, Your Lordship, the second point is IO has said that yes, I have collected the specimens, but he has not identified that yes, these are the signatures of this person in that document. Because mere exhibition, Lordship, the law is a mere exhibition is not proof of a document. The document has to be proved. Specifically when handwriting is a very essential, Lordship. He has not done that. He has only said one statement that yes, I have collected signatures of the accused persons, specimen signatures of the accused person for handwriting analysis. But he has not identified the
So
document.
it's not exhibited the specimen signature. Exhibited. Exhibited.
Signature is exhibited, but he has not
Whose
identified.
signature he has not said.
He has not said that.
That this is the signature of so and so.
Yes. So we do not know what
the document itself will reflect.
No, that we understand. That is his argument.
that is. So without mere exhibition, Your Lordship, without proving it, that will not fulfill the requirement of 47, Your Lordship, and therefore, if that specimen those specimen signatures cannot be relied could not have been relied upon by the handwriting expert to arrive at his opinion. And that opinion, which in my opinion, which in my submission, Your Lordship, appears to be the primary ground,
Evidence.
primary evidence on which the conviction was, which the lower court.
So basically, your sanctity of the procedure, even if you argue, if you are arguing that even if that procedure prescribed is not applicable at that relevant point of time, however, there were witnesses.
Yes.
For proof, witnesses of collection of specimen
Yes.
signature.
Yes, sir.
2 witnesses has been withdrawn by the prosecution, and those 2 witnesses brought on record, they have not whispered that specimen signatures were taken in their presence.
Yes.
Therefore, this will be fatal, and it will be doubt will create. In view of that, the prosecution has, even after having witnesses, have failed to so why this was withdrawn and why they have not stated anything regarding the specimen signature.
Yes.
And therefore, it has created a doubt on itself regarding collection of the specimen
Collection of the specimen.
signature.
Yes.
This is your
Yes.
give a note on next that
Very
we are bordering you.
No, not at all, not at all, Your Lordship.
In reply, Lordship, whether non-examination of those witnesses.
That will be issue C. In certain cases, when prosecution withdraws vital witnesses, in given facts of the is a case that can be fatal in some cases. And in some cases where evidences are clear, some withdrawal will not damage the entire prosecution case. This is the principle of law.
It is the prerogative of the prosecution who will examine.
No, the prerogative is fine, but at the same time, that prerogative should not go against the prosecution. Prerogative is there, but Supreme Court time and again says that certain witnesses which are very vital, withdrawn, then itself creates a doubt. There are judgments, and in some cases says yes, that witness was important witness, but non-examination of that witness has not damaged the or dented the prosecution case because there are other clear evidences. This is the law.
Here in this case, there are other clear
Evidence. So that will say, so clear it. So he will say that your whole case is the specimen signature. What is the reason you have withdrawn the independent witness and relied on the person, the prosecutor himself? This is their case, isn't it?
Yes. IO cannot be the sole witness.
More particularly when you rely on this is I could understand. Please this matter for further hearing on. Last date of last date of before vacation. No, need not worry. 4th of October.
4th of October, I'll be going.
Go out, you keep some.
And so far as me is concerned, my lord, and I have already mentioned in my written argument that there is no
See,
whisper.
Mr. Pukashta, just
My-
I'll tell you, I have an achievement in my life amongst many others in this case. So therefore, don't destroy that achievement. You are welcome. We'll be happy to hear your arguments. But we are more happy to have a very precise written argument from you. I think this is the record for me.
Lordship, may kindly have a look into my argument.
No.
I just hesitate to.
No, your argument is fine. For you, it is fine. But for Mr. Purakash, confining a written argument within a, how much pages?
Today, my lord, 8 things.
8 pages.
Finally,
Is an achievement for this court. His written arguments was how much pages? Earlier written argument?
8 something.
68 pages. So this is an achievement for this court.
Finally, Lordship, in my argument also,
Hmm.
finally I wrote the prosecution, the finding of the special judge in judgment so is based upon conviction of record. And particularly the evidence is transferred that the sequence of events so proved by the person forms a complete change where.
See,
So I have
basically
submitted-
circumstantial evidence. One of the important chain of circumstance is the specimen signature.
Specimen.
Main link. So that what we'll look into. That we cannot deny. Nobody can deny. Because there is no direct evidence.
Correct.
There is no direct evidence that this person has done it.
I mean, my lord, the opinion given by the handwriting expert.
Huh.
And in one line in the last part of the opinion, he said that I cannot come to any conclusion. I will refer to my, I have mentioned in my.
You have mentioned. We'll hear you.
Bless you.
Refer to certain judgments.
Ah. You can give it, we
On the
can
last-
collect it also as you wish.
On the last data.
Last that, if you give, then it's easier for us,
Oh.
then again we'll have to ask them.
Madam, my judgment is already on record. madam.
Already.
Let me do one thing, Lordship, with the, along with my written argument,
Ah.
I'll enclose.
Yes, you can take it, Baba, give the copy because I have marked it in the meantime.
Today I'll give.
And I have noted down his points, 2, 3, but though it's not readable, you will not be able to read it.
I'll give it now only.
Yes.